Welcome everybody to the Selwyn District Council meeting of the 24th of July 2024. I'd like to welcome you all here today. We have a number of public forums. Thank you for coming to express your views. We will start with the opening karakia and the council affirmation. Please stand. Whakatakata te hau ki te uru, whakatakata te hau ki te tonga, kia mā kina kina ti uta, kia mā tāra ki tai. Ihi aki ana tika rua, ki e tio, he huka, he hauhu, ti hei Māori Ōrī. Let us affirm today that we as members of that we will work together as citizens of the Selwyn District to always use our gifts of understanding, courage, common sense, wisdom and integrity in all our decisions, dealings and decisions so that we may solve problems effectively. May we always recognise each other's values and opinions, be fair-minded and ready to listen to each other's point of view. In our dealings with each other, let us always be open to the truth of others and be ready to seek agreement, slow to take offence and always be prepared to forgive. May we always look to enhance the well-being of the Selwyn District Council and its communities. We will. Please be seated. Right, today we have, as I previously mentioned, any identification of extraordinary business, CEO? Being none. Any conflicts of interest around the table? Being none. We'll now move on to the public forum, and I'd like to invite Kirralie Fee and Claire Linehan to take a seat at the end, push the right-hand button for the microphone. You have 10 minutes for your presentation, and we will ask any questions for clarification afterwards, but we won't be entering into any debate. Lead the way. Oh, and as far as the timekeeping goes, there'll be one ting for 8 minutes and two tings for 10.
Oh, okay. Good afternoon. Kia ora, everybody. My name is Claire Linehan and I'm the lawyer representing the Upper Selwyn Huts. I do have a request, Mr. Chair, and apologies for any confusion. There's 4 speakers on the list today and we ask that myself and Ms. Kirralie Fee are able to speak on behalf of those 4 speakers. So if we're able to have their allotted time, that's the request before you, Mr. Chair.
We have 3 speakers registered today. Kirralie Fee and yourself, Graham Evans and Kara Sedenka.
Yes, so, sorry, the 4 of us altogether.
Okay,
yes.
Good as gold. Yes, certainly.
Thank you so much.
The floor is yours.
So I'm relying on the bells.
You'll be fine.
And Kirralie. Thank you. And hopefully you've got my submissions of today's date before you.
Yes, thank you.
Thank you very much. So as I said, my name is Claire Linehan and Kirralie Fee and I will be presenting submissions to you today on behalf of the Upper Selwyn Huts residents. The residents are very grateful to have the opportunity to submit to you on the Council March 2024 resolutions, which, as you are aware, have been a great source of distress for the residents over the last few months. Importantly, the residents agree with the council staff report that this is a significant decision in the context of the council's significance and engagement policy, and a full consultation process is appropriate, and that the council pause the current process and embark on an engagement and consultative process. Some issues that the residents have include the prior consultation, and I think you're aware of that through the residents' communication, and I wrote a letter to council. I'll talk a little bit about that as we go on. The purpose and scope of the staff report is a concern because it's described as to develop a proposal for the eventual removal of the Upper Selwyn Huts. The residents consider this as premature, too narrowly focused, and erroneously based on the council resolution in 2019 that hut licences and subsequent renewals are short-term and ultimately finite for a finite period. As the recommendations and proposed engagement process flow from this purpose and scope, it's important it is focused on current relevant issues and clearly identified, and I'll talk about that in more detail further on. Residents have an alternative suggestion that the scope could be future licensing arrangements for the Upper Selwyn huts. Item 4C, the finite term rationale. None of the reasons in the staff report justify a finite term, and the recommendations leave this issue hanging over the residents' heads unless council resolutions 2, 3 and 4 of item 3 of the March 13, 2024 meeting are revoked, which residents believe is justified for reasons set out in these submissions and the submissions of Ms. Kirraly-Fee. In terms of the engagement process, given the significance of this issue, the residents consider it appropriate they be consulted about or engaged with about the scope, form and detail of the proposed community engagement via collaboration and empowerment in accordance with council's significance and engagement policy. There's also an issue with the proposed hut inspections. This regime is premature. There is no similar mechanism in the current licence. Although there is provision for inspections in the draft deed of licence, residents have not yet had an opportunity to provide feedback on this. Without any obvious reason for this regime needing to be implemented now, and given the lack of consultation and feedback, residents consider this issue can be dealt with along with other terms and conditions of the draft deed of licence. And finally, this isn't so much an issue as for the council's information, the residents recently engaged historians to complete a statement of significance report for the Upper Selwyn huts. The report is in draft, but because of the significant values identified by the historians, they consider the Upper Selwyn huts remain on their current site, that the huts are entered into Heritage New Zealand list as a historic area, and that they are added to the Selwyn District Council's District Plan Heritage Schedule. So my submissions today will cover the issues with prior consultation, the significance classification of this issue, the stated purpose of the staff report and engagement, the historic and cultural significance of the Upper Selwyn huts, some comments on the staff report and some suggested amendments by the residents to the recommendations before you with to the recommendations and the proposed engagement process. And Kirraly-Fee will cover the reasons for the staff recommendations which flow from the stated purpose of developing a proposal for the eventual removal of the huts. And I've listed there what she'll be covering. So just on to my submissions. I'm now at heading A, item number 7, paragraph 7. I'm aware that the councillors have received my letter of May of this year, but because councillors are not obliged to accept any of the recommendations in the, I'm just talking off my papers now, because the councillors are not obliged to accept any of the recommendations in the staff report, residents felt it prudent to reiterate some of the points in that letter in relation to consultation. So that's what I'm going to do from paragraph 7. And just moving over to paragraph 8, as I mentioned, the residents have communicated both formally and informally about the issues they had with the March meeting, where they had 2 working days notice to digest the contents of the extensive 174-page submission with the draft deed of licence. So in terms of the Local Government Act consultation in paragraph 9, the essence of those provisions is that although council has some discretion about how it achieves compliance with the requirements of decision-making and consultation, it is largely in proportion to the significance of the issue and considering the principles of local authorities under the Local Government Act, which include it should conduct its business in an open, transparent and democratically accountable manner, give effect to its identified priorities and desired outcomes in an efficient and effective manner, make itself aware of and should have regard to the views of all of its communities and take account of the diversity of the community and the community's interests within its district or region and the interests of future as well as current communities and the likely impact of any decision on each aspect of the well-beings referred to in section 10 of the Act. And at paragraph 10, I've just listed the principles of consultation under the Local Government Act, which I'm sure that you're all familiar with. And in the interests of time, I'll just go to paragraph 11. The council has a discretion, as I've said, about giving effect to the above principles as it thinks appropriate in any particular instance. But as I've mentioned, this must be informed by the nature and significance of its decision and the likely impact from the perspective of the people who may be affected. And paragraph 12, as has previously been advised to the council, both formally and informally, the residents consider they did not have reasonable access to the relevant information in a manner and format appropriate to their preferences and needs. This is referring back to the March meeting. They were not encouraged to present their views to council. If council had genuinely encouraged them, it would have consulted residents much earlier and given them plenty of time to digest the information and further adequate time to prepare submissions and present them to council. They consider they were not given clear information about the purpose of the consultation or scope of the decisions to be taken. And again, with only two working days' notice, there was little time to consider anything. And at item D, they were not given a reasonable opportunity to present their views to council in a manner and form that was appropriate to their preference and needs. And at item 13, residents have communicated to council they consider that this issue was not correctly classified in terms of its significance. Under the council's significance and engagement policy, it was classified as moderate when it should have been classified as an issue having a high degree of significance. They consider that they weren't consulted in terms of the requirements of the Local Government Act, as I've mentioned, and also importantly, that council acted unfairly and breached administrative law principles for fair decision-making and natural justice rights. And at item 14, I just set out what the residents sought from council in that May letter that I submitted to council, and they sought an acknowledgement about the unreasonableness of the consultation. They sought that council revoke its 13th March resolution and put all four options back on the table, and that the significance in item C be reclassified. And at paragraph 15, I just want to make very clear that the residents no longer seek that those four options be put back on the table because they acknowledge that things have perhaps moved on and there's a broader subject matter can be encompassed by its suggestions, its suggested modifications to the council staff recommendations. So moving on to the significance classification of the issue, the nub of this really is that the residents agree with the recommendation put forward in the council staff report that the significance is high rather than moderate. And at in item 16, I've set out a list of the reasons why, which are taken from the council's significance and engagement policy. So I won't bore you further by reading those out. I'm sure you're all very familiar with them, but and to be clear, this is council's significant and engagement policy that was relevant at that time in March 2024, not the current new policy in terms of the council's brand new long-term plan. So moving on to C, the purpose of the staff report and engagement. And this is very important to the residents. They consider, excuse me, that the purpose and scope described in the staff report, which is to develop a proposal for the eventual removal of the huts, is, as I alluded to, premature and too narrowly focused. In the scope section of the staff report, it also states, council has decided that at some point in the future, the Upper Selwyn huts need to be removed from this location. I've been unable to find the resolution supporting this decision. It appears to have been carried over from the March 2024 council report, which in turn was based on the council resolution in 2019 that hut licences and subsequent renewals are short-term and ultimately for a finite period. Paragraph 21, the May 2019 finite period resolution was made in the context of issues with finding alternative solutions for wastewater, as Environment Canterbury would not renew the old wastewater resource consent. The report provided to councillors in 2019 stated The key date that needs to be kept to the fore when considering the issues surrounding the Upper Selwyn Huts licence renewal is that the wastewater discharge consent expires on the 30th of June 2020. This is the same date that the licence expires, and then the two dates are of course linked together. In paragraph 22, the term finite in the context of the 2019 resolution was in direct connection with the wastewater issue, described as one of the big issues, and alongside that, the funding thereof. There was a further statement that this will be the key to resolve, and I believe this is fundamental because since that time, the key issue, of course, has been resolved with the Pines wastewater treatment plant extension to the Upper Selwyn Huts community. At paragraph 23, as noted in the staff report provided for this meeting, the council decisions in relation to the community were originally based on the premise that any future deed of licence was to have a finite and short-term life. These decisions were made in the context of an uncertain wastewater system. This uncertainty has now gone. As the recommendations and proposed engagement process flow from this purpose and scope, the first question of the proposed engagement process is, what does a transition away from hut life look like? It's important it's focused on the current relevant issues and clearly identified, because from that purpose, everything else flows. And if that purpose is erroneously focused on a mistaken set of facts now, it's not helpful for residents or the council to proceed on that basis. At paragraph 25, given the basis on which the March 2024 resolutions 2, 3 and 4 were made, and I've included those in the appendix to my submissions for your assistance, and for the reasons that Kirralie Fee will talk to you about soon, the residents consider it appropriate these resolutions be revoked. The residents consider the suggested scope, as I alluded to moving forward, could be future licensing arrangements for the Upper Selwyn Huts. Section D, historic and cultural significance of the Upper Selwyn Huts. Residents recently engaged a firm Underground Overground Archaeology to provide a statement of significance report. The report is draft at this stage, but to assist you today, we thought it convenient to provide you with the draft statement. The report concludes, the assessment of the heritage values of the Upper Selwyn Huts finds the place to have special heritage significance as a testament to the recreational sport of angling and the small fishing hut communities that once graced New Zealand's river and lakefronts in the 19th and 20th centuries. The huts are an example of an increasingly rare type of vernacular architecture which represents the Kiwi number 8 wire tradition of do-it-yourself. The huts were known nationally and even internationally, attracting even peers of the realm. The settlement evolved into a small batch community representative of the type that was central to the traditional New Zealand holiday experiences during much of the 20th century. For these reasons, the Upper Selwyn Huts are assessed to have significance for their archaeological, architectural, cultural, historical, and technological values. The report recommends that because of these significant heritage values, the Upper Selwyn Huts remain at their current site. They are entered into Heritage New Zealand's list as a historic area, and they're added to the Selwyn District Council's District Plan Heritage Schedule. Once the report is finalised, residents will provide council with a copy. Moving on to section E, comment on the staff report and suggested amendments. As I've mentioned, Kirralie Fee's submissions deal in detail with the various reasons provided by council staff to justify the purpose and scope of the report and recommendations, including the eventual removal of the huts. Kirralie's submissions are an important component of the reasons residents seek for their proposed changes, which I'll get onto in a moment. In terms of hut inspections, at paragraph 31, the proposed inspection is mature. There is no mechanism in the current licence that allows hut inspections. There is provision for inspections in the draft deed of licence within 12 months of the commencement date of that deed, but residents have not yet had an opportunity to provide feedback on that even, and do not agree with that clause as proposed. The recommendations in the staff report are far more detailed than the draft deed of licence. They have appeared out of the blue without any obvious reason for inspections to occur now. The residents have not had an opportunity, as I've said, to consider the ramifications, and they're not familiar with the 1947 home improvement regulations, which are stated as the regulations that apply to these huts. Given the above, the lack of consultation and the fact this is a substantive issue that can be dealt with along with the other terms and conditions of the draft deed of licence, the residents disagree with this recommendation in the staff report and seek it be deleted. In terms of other suggested amendments to the staff recommendations, paragraph 34, flowing on from the above, the residents request the council consider the amendments below to the staff report, and the additions are shown in underline for added words and strike through for removed words. And as I've already mentioned a few times, paragraph 35, it's important to deal with the currently standing resolutions made by the council in March 2024. If the council accept the recommendations of council staff as suggested to be modified by residents, these resolutions will need to be revoked. So at paragraph 36, hopefully you can see I've just transplanted the staff report recommendations and inserted additions. And for example, the first major one is little paragraph CC, which I inserted because I didn't want to interrupt the flow of the staff report. And that's in relation to the future licensing arrangements of the Selwyn community having a high degree of significance in terms of the council's significance and engagement policy. And the residents thought it was important that this be mentioned specifically. Item D is in relation to the contribution to the operating costs for the wastewater treatment plant. And as council staff and councillors are aware, the residents are concerned and very eager to be included in a district-wide rate rather than having a targeted rate for the wastewater treatment plant. So that's item D, a suggested addition there. Over the page, at paragraph E is where I've inserted EE, little paragraph EE, is the suggested amendment to revoke the resolutions that are still on the table. And the last major amendment to these recommendations are item G, which relates to the proposed inspection regime, which the residents request be deleted. And then moving on, there are some suggested amendments to the proposed community engagement, paragraph 37. The residents consider it appropriate they be engaged with about the scope, form and detail of the proposed community engagement. Residents request as a starting point, the proposed community engagement be amended as follows. And again, I've underlined added words and strike through removed words. And in essence, the residents are suggesting an element of flexibility in what's been proposed by the council staff, which I understood from the wording proposed was a starting point. And flowing from the alternative purpose that the residents have proposed, there are some suggested amendments to the 3 sessions that have been proposed. So session 1, still at paragraph 37 here, instead of what does the transition away from hut life look like, excuse me, which was related to, I'm going to have to, excuse me, a bit of water. Oh, thank you. The original question for session 1 was related to the purpose the residents consider now as no longer appropriate, because that related to the finite term that council resolved to impose in 2019, which flowed through to 2024. Instead, the residents consider the broader question, what might the future of hut life look like, which is broad enough to entail room to include concerns of all parties in my submission to you. And the suggestion is that this session could incorporate all current relevant information relating to, for example, climate change and sea level rise, which are clearly concerns of council staff and the council. And the council's legislative obligations, which the residents are mindful of, in relation to the huts and the welfare and interests of the residents. Session 2, flowing on from that, what options are available in relation to the issues identified from session 1. So again, fairly broad, and kept most of the wording suggested by council staff, clearly in relation to a different purpose now. And then finally, session 3, which is extremely broad. What is the best approach? Because clearly that's going to depend on what flows out of session 1, and then clearly there'll be some more detailed information in session 2, which will guide what's going to happen in session 3. So those are my submissions to you today, and I'm happy to answer any questions. And as I've mentioned, Ms. Kirralie Fee is going to provide a lot more detail about some of the matters that council has considered in relation to its March 2024, the reasons behind its March 2024 resolution. Thank you, Mr. Chair.
Thank you very much for a succinct and well put submission. Thank you very much. Councillors, some questions. Who's first here? Deborah.
Right. Look, thank you. I have a question on page 2 of your report, and it's under F, and it's the cultural, historic and cultural significance of a report. Has this process been undertaken previously? And if it was, why was it then not adopted by HNZT-PTS?
So I think there's two different things going on here. My understanding is, so the report is a broad report by historians who are engaged as private contractors, and as part of their report they make several recommendations, and one of which is what you're alluding to, an application to go on the Heritage New Zealand list. And I am aware, Kirralie, Ms. Fee might be able to give you a bit more detail, that there was an application made some time ago. I'm aware of that, and I'm also aware of the reasons why Heritage New Zealand declined that application, and in my submission those reasons were not relevant.
Okay, so your reasons, so you're acknowledging that there was a previous report?
Well, no, I just need to be clear. So there's an overarching report. No, I'm not aware that there was a previous historian's report about the statement of significance. That's a separate issue. I am aware that there was an application by the residents themselves made to Heritage New Zealand, and that was declined.
Yes.
And the reasons for that, as I've said, I don't believe are relevant to Heritage New Zealand's reason for decline, but that hasn't been followed up. I'm just sharing that with you. But I'm not aware, but Ms. Fee can let you know that there's been a previous statement of significance report done by a historian. Does that answer your question?
Yes, it does. I mean, basically, of your understanding, there was a previous request by the hut owners and a previous report to the Historic Places Trust, and it was not actually accepted by them. So that's the previous one.
Well, yeah, but there was no expert report by a historian provided with that application, is my understanding. So what's new now is there is an expert report by a historian that is much broader and more high level than just an application to Heritage New Zealand to be included on their list. As I've said, there's three main recommendations, and this is the draft report. The three main recommendations, one of those recommendations was to be put on the Heritage New Zealand list. And then the other two recommendations aren't reliant on going on that list. They related to, being included in Selwyn District Plan's heritage list.
Thank you. Councillor Dean.
Thank you for consolidating the issues down to the 10 pages. It makes for much easier reading. Look, I just wanted to clarify something. You mentioned on your page 8 under EE, the revocation of resolutions 2, 3 and 4 from the March meeting, which you said was still on the table. Now, I just want to clarify that we are talking about the ones that we passed on that day. Okay.
Yes.
So
yes.
they're not on the table though. the past.
Sorry,
No, that's right.
that was my incorrect
I was
expression.
trying to make sure that I understood which ones you were talking about.
Yeah,
You're
no,
talking
that's
about
right.
three others.
And I've included them in appendix one.
That's what.
Yeah.
Thank you. Just wanted to clarify. Thank you.
Thank you, councillor Dean. Councillor McInnes.
Yeah, thank you very much. And thank you to everybody here as well, actually. The heritage part is new to me, so my question is around this bit. Mainly along the lines of, do the residents, as far as you're aware, foresee this becoming just a heritage site, or would the buildings also be covered under that? And I ask this because I'm aware that some people who have had their homes declared to be a heritage building then find that this imposes a great deal of restrictions on them in terms of if they want to upgrade or amend or do any kind of work on their homes. And there is no funding really that supports with that. And so I'm trying to find out, is it site, buildings, both, that sort of thing?
Well, I think there are a myriad of possibilities, and probably we'll have to wait to get the report. So one of the possibilities is that because it predates 1900, that it's an archaeological site in terms of the Heritage New Zealand Pāhuri Taonga Act, and that has certain ramifications. But I think the historians will have to identify whether any of the buildings are pre-1900. So the reserve obviously predates 1900, and there's evidence there were buildings there prior to 1900. But are those buildings still there now? We won't know until they've inspected the building. So that's one possibility. In terms of, and then it may be listed on Heritage New Zealand's list of buildings. In terms of restrictions, I'm not sure yet what, if any, there may be, because the report is still in draft, and so I'm afraid I can't answer that. But as soon as that report's available, which I understand will be within the next month, that will be provided to council. But I have seen that this same company has done another assessment for another group of historic huts, and that's a final report, and there wasn't any mention in there of any limits or restrictions that might be placed on hut owners. So I can't give you any more detail than that, sorry.
Councillors, there's no other questions? Thank you, Ms. Lenihan.
Thank you, Mr. Chair.
Thank you very much. Now, Speed.
Hello, my name's Kirili Fee. I am here representing the committee and the community of Upper Selwyn Huts. We thank you for your time hearing our submissions today. We also thank Tim and his team for all of the work they have done over the past 3 to 4 months. We commend them on the recommendations to reclassify our significance to high, consult under a more collaborative model, and consider us for district-wide rates. Thank you for listening to us. We do, however, believe these recommendations do not go far enough. We note the finite decision made back in March, as well as the inspection program, have not been included in the scope for this extended consultation. We believe all issues should be included in this collaboration. There are no reasons to include some clauses in collaboration, but exclude the finite decision and inspection program. With that in mind, I'd like to address why the reasons for the finite decision need to be part of this proposed collaboration. Climate change. Your current proposal on climate change adaptation is brutal and not consistent with international standard practice. Standard practice involves full community involvement in decisions, mitigation, investigations, and when retreat is required, pre-planned relocation and compensation. This practice is consistently included in 90% of the submissions to the Select Committee on Climate Change Adaptation currently being heard in Parliament. Standard practice ensures residents are not left in a worse position after retreat. None of these have yet to be considered by the Council. I do not have time, unfortunately, to describe the multiple mitigation options that are available. Some have already been agreed upon by ECAN. However, investigating these needs to be included in the proposed extended collaboration, and this should be done before a finite decision is made. Additionally, we question whether extreme event modelling RCP 8.5 used in the Aqualink report should be used for council decisions. NIWA's website does not support this modelling. It is clear that the climate change reason for the finite decision needs a lot more collaborative work to ensure the correct information is being used, standard practice is being followed, all alternatives assessed, and that the financial and welfare of our community are properly considered. Coordinating all hut settlements. The hut settlements differ in many ways, so coordinating the licenses does not have merit. They differ in applicable legislation, water and wastewater infrastructure, distances from the lake, heights above sea level, available mitigation options, and Upper Selwyn Huts is outside of Te Waihoa's joint management plan area. All hut settlements are still in negotiations with outcomes yet to be determined. For example, Te Taumutu Runaka have recently voted to allow Taumutu family to stay long-term in their homes at Green Park. Developments like these are ongoing and independent from each other. Our future should not be coordinated with any other hut settlement. Major stakeholders. ECAN. The Council's March report states that ECAN wanted any new deed of licence to be finite. However, Peter Scott from ECAN has confirmed twice that there was no such decision made by ECAN. Please disregard this reason to justify a finite decision. Te Taumutu Runanga. Liz Brown and Megan Mackay collectively have expressed their desire that any future lease be finite. Their combined reasons are that we impact on mana whenua, their ability to practice mihinga kai, and the health of the lake. To our knowledge, we do not impact on these. However, we asked the Council repeatedly on the details of these impacts. The Council have not been able to provide these. However, if the Council is to use these impacts as a reason to be finite, the details of these should be readily available to both our community and the councillors. Further, multiple attempts have been made to engage with the Runanga to see if we can reduce our impacts, if any, and so far all attempts remain unanswered. Our community and the councillors require further details and collaboration on these cultural reasons before these can be used to justify the finite decision. Safe permanent residency and the council's duty of care. To justify the finite decision, the council are saying we were never meant to be permanent, which also relates to the council's duty of care obligations. We don't believe you should be using the council's own permanency decision as a reason to eventually terminate our licence. We instead ask you to consider collaborating with us to help us ensure you are meeting your legal obligations, and in the process, we can help reduce the administrative burden. Clearing a village seems an extreme solution to your permanent residency and duty of care concerns. Additionally, the current licence does not include an inspection program. We have been asking for details on this since April and have only just received it. We still have many questions about the checklist and its implications. Our current feedback period is not over yet. The inspection program should be included in the collaboration and should not begin until it is included in a signed deed of licence. We are gravely concerned about the consequences of these inspections. Repair of the reticulation system. The council has owned and been responsible for the repair and maintenance of the sewer reticulation system since 1989. Further, the committee which administered the settlement before the council took over in 2011 had planned and budgeted for the gradual replacement of the system out of the current licence fee at that time. This decision was not adopted nor implemented by the council since 2011. Independent legal advice currently in draft form regarding the reticulation system states the council has, through both licence and action, asserted ownership of the reticulation infrastructure, and that as per the council's revenue and finance policy, reserves should have been built up for the renewal of the system. For these reasons, the repair of the sewer reticulation system should be carried out by the council and not be used as a reason to impose a finite decision on the settlement. The new wastewater pipeline and its funding. The wastewater upgrade or the funding thereof should not be considered in relation to the finite decision. The new system will have a useful life of 50+ years, so finite is not justified. As you all know, the community strongly believes we should be included in the district-wide rates for sewer and water. This is with particular reference to the Council's 2015 Long-Term Plan Towards 25 document, which proposed to adopt a new approach where consistent costs should apply to all residents who receive a similar level of service for key infrastructure. This was further supported by the 2018 Development Matters Report, 2019 Buddle Finlay Advice, 2022 Douglas Marshall's recommendation, and Tim is now reconsidering this option. Further, our independent legal advice, currently in draft form, states, amongst other things, if 25 out of 26 water schemes and 16 out of 17 wastewater schemes pay for these services by a tax, why is one of the schemes paying for the same or similar service through user charges? We welcome the opportunity to consult further on our request to be included on the district-wide rates for water and wastewater and ask the Council to no longer include wastewater to justify the finite decision. As you can see, all of the reasons the Council have given to us do not justify the finite decision, so we request that these reasons and their solutions be included in the extended collaboration process. Further, we also have our own reasons to justify us staying for a longer term. We have not been given a chance to include that in our feedback yet, with the deadline currently 26th of August. We have not provided you with our legal advice on the reasons why we believe a finite decision should not be made, nor our historian statement of significance, which confirms our archaeological site status. This feedback was going to be completed and provided to the Council before 26 August deadline. As you can see, Tim's report only covers a very small part of the information we have about all issues affecting our future. In order for the Council and councillors to fully understand our situation, a full collaborative approach on all topics affecting the decisions on our future, including the finite decision, must be taken. We also suggest the timeframe recommended needs to be more open-ended. This is a very complicated process with multiple issues and debates, which cannot be condensed into an agenda report. For these reasons, we would like to request the finite decision and the inspection program to be included in Tim's recommendations for future collaboration. It doesn't make sense to restart under a new model, but exclude some decisions. We have a chance today to change the Upper Selwyn Huts and Selwyn District Council narrative. We can change our story to two parties working closely together to find a mutually acceptable outcome. We are excited about this opportunity to have full extended collaboration about all decisions about our future appropriate to a high significance classification. Nothing about us without us. Thanks.
Thank you, Ms. Fee. Do I have any questions from around the table? I do. Councillor Hassan.
Thank you.
Hi.
Just a query on your comments around the repair of the reticulation system.
Yes.
You have actually said that the council owned and had been responsible for the repair and maintenance of the sewage reticulation system since 1989. Then you say that further, the committee was administrated the settlement before the council took over in 2011 and had planned and budgeted for the gradual replacement of the system. With regards to the previous committee, are you aware that previously the occupancy rate around that time was 12 permanents and the rest were not to be permanent? And a significant argument was always put forth that the existing plant could cover 12 months occupancy by all of the hut owners that were available at that time with regards to maintenance of the reticulation supply. Are you aware of the history around that from previous
I'm somewhat
minutes?
aware of it. I haven't been here for that long.
Okay.
Yeah. But the legal advice has told us that the council should be responsible for replacing that and paying for the reticulation system.
Right.
So I think those decisions back then might be a bit irrelevant.
The reason why I'm asking was I was actually a
I'm
committee
aware.
member at the time.
Yes.
So I am well aware of the issues around the previous sewage system that was there, who was responsible for it and how it came to be, and the ongoing maintenance around from 1995 through to 2011. So just want to highlight just some clarification because it seems like a little bit inconsistent
Sure.
with ownership. Okay, thank you.
Okay.
Thank you, councillor Hassan. Councillor Miller.
Good afternoon.
Hello.
I was listening to your submission point about inspections of the properties. And initially I was sitting here going, well, that makes sense what you're saying. I mean, they've been there for 100 years. Why does it matter? We wait another 6 months to have a look at them. But then I was thinking, well, fundamentally, you probably want to have a stock take of all the assets and the houses as part of this consultation process before you agree a new deed of license, so that there's no hidden costs or things that might pop out of it. Have I got that wrong, or was that? I mean, what is the fundamental reason you're against having an inspection? I mean, the key concern, my understanding from the council, is particularly around stormwater going into sewage lines and those sort of things.
Yes.
So it's not, and I think the last meeting that I was at, I think we're not going into the process trying to be obstructive, more to be enabling and saying, well, there's a small problem here, can we fix this? What will it take to fix this? So if you could perhaps further elaborate the reasons why you would not like us to inspect properties.
Sure. What we would like to do is have more information about the inspections to understand there's a checklist there, but we want to know exactly what they're looking for. And then maybe if we could, if we agree to the inspection, which is the stage we haven't, then we could have we could be more prepared. We could, if there's repairs, then we could repair it before. Our biggest concern that in 2023, one of our residents was red stickered from an inspection as he was made homeless on the day. And they were for two reasons that were easily resolvable. One was incorrect. He did actually have a compliance certificate for the fire. And the other reason was electrical, which he got fixed on the day. He shouldn't have been red stickered. And because of that, we are very concerned of opening the door to allow this to happen again. Inspection programs should not be there to make us homeless.
Hearing what you just said makes me understand where you're coming from, and that was what I was hearing from our suggested process was not going to be in that vein, but I can understand now why you feel like that. Thank you.
You're welcome.
Thank you, councillor Miller. Councillor McInnes.
Yeah, kia ora, Kiralee. Thank you
Kia ora.
very much for coming. Thank you very much for your submission. It's actually really good to have both these as they are. That's made it much easier for taking notes. So thank you very much for the format as well. I really wish that nationally we had a system set up for dealing with these sorts of processes in a format that was easy for everybody to follow and understand. I know that there are hearings and everything going on nationally about that, but when we have it in place, I don't know. So anyway, yeah, your submission mentions compensation, and I guess that was where I was going with it, that actually nationally there isn't, that's one of the things they just haven't actually worked out yet. Hopefully we'll get more certainty on that soon. Anyway, my question was around
Can I
You've
speak on
mentioned
that?
about-
Can I speak on that comment?
Yep.
Thank you. Huranui, as you know, have a fantastic and award-winning compensation package, which doesn't affect the ratepayers and also gives multiple options and choices to the residents at risk. And that is land banking. Land banking is a very real option to allow compensation regardless of what the select committee decide in the future. It is something that Selwyn District Council can consider for the Upper Selwyn huts, and it won't cost ratepayers. It shouldn't cost ratepayers anything.
as far as I'm aware, the Huranui version does require the ratepayers to buy the land first. And that was to be agreed during their LTP this year, and I'm not sure whether it passed or not. So I haven't seen that yet.
But then extra sections were going to be sold to pay for it, to pay for the development.
Correct,
Okay.
but the debt had to be taken on first, and also the land in Huranui is far cheaper than the land in Selwyn, unfortunately.
Questions?
The question was around the statement that NIWA's website does not support using RCP 8.5.
That's great.
So that's RCP 8.5 is from the IPCC's 5th report. They've now got the 6th, and they're using the SSP modelling. And I have seen elsewhere recommendations that until internationally and nationally our policies actually direct emissions to be reduced in line with not a fossil fuel future, that we should continue to use the highest modelling because we're not actually on track to going anywhere lower. So I guess it would be interesting to see more about that, because at the moment there's the conflict between, there's the aspiration that we shouldn't have to use RCP 8.5, but actually the reality is still SSP 5.
NIWA's website does not support that, clearly states it does not support using.
Councillor, we're not into debate at this
Yeah.
point. We're having
Okay.
questions. Representative Mackay.
Kia ora. So my question is actually more for the chair rather than for Kirali. And I just wanted to know, later in the paper in the agenda, we have the paper coming up over Upper Selwyn Huts engagement and consultation. And I wanted to know from you when it would be appropriate for me to share how Taumitu has engaged and will engage. Would you, given it's been raised here, would it be appropriate to address that in public forum or when this paper comes up a bit later in the agenda?
Possibly, when it comes up in the agenda, I think would be better, Representative. Councillor Glidden.
Hi, Carolee.
Hi.
Look, I just want a little bit of clarification around the hut inspection. So you're not against the inspections. It's just that you need more information and understanding of the implications.
I think overall we're against the inspections, but if they are to go ahead, if we do agree on something mutually, then we would like to have collaboration on how that can go ahead and to ensure that we will not be made homeless during this process.
So would you potentially say that it needs to be more of a consultation approach to the hut inspections?
Definitely collaboration in regards to the form, the details of it. Yes, definitely part of the collaboration process. That's what we're asking, to include the inspection process in the collaboration proposed by Tim.
Thank you.
Thank you.
Councillor Munt.
Hi, has the council come back to you with the reasoning around why they're wanting to add the inspection process to the deed of license now when you've never had an inspection process in any of your other previous deed of licenses? And is there an element of trust missing between dealing with the council that you feel would potentially be remedied by the amendments, the proposed amendments, in which the engagement and consultation that will undergo between council and yourselves, if it's to tackle all of the proposals and be put into that engagement opportunity, so that you have a whole a much wider bracket of things to discuss rather than us going ahead with all of the recommendations today?
Sorry, can you just simplify your two questions? I've heard what you're saying, but can you just simplify them one by one?
Yeah, so we've got a number of recommendations today that we go through,
Yes.
but your request between yourself and Claire have been that some of those things are taken off those recommendations and are put into your engagement and consultation period with council. Would that help to build the trust between council and the community? And
Yes.
do you feel, is there an issue with trust at the moment?
Yes.
And the first one was, has the council come back to you with why they're wanting to propose an inspection program now when it hasn't in the past been something that's been a part of your deed of license?
Try and remember your questions. There is a lack of trust, unfortunately. A lot of that goes back to history, but also the fact that the council have asked DOC to administer us last year and DOC has refused. So we know that you don't want us there, and we know that you don't want to administer us anymore. So we look at everything that you give us in those, with those goggles on, and we are aware that anything we agree to may end up with a termination of license. So we do not have a lot of trust, but Tim is proposing a collaborative approach and a reclassification of high significance, and that could go a very long way to building trust between the two parties. That could go well into the future, and that's what we're excited about. Did that answer your question?
Yes, thank you. And the first part of that, sorry, was in regards to, has the council given you a reasoning why they're wanting to do inspections now when it's never been in your deed of license before?
Yeah, we have no idea why it's being pushed through and not being part of the collaboration process. In order to restart the whole process under high significance, collaboration and empowerment, all topics should be included. You shouldn't be cherry picking one and then not the other. I mean, you either want to restart the process and start again under a new model, or you don't.
Thank you. Any more questions? There's no more questions. Thank you, Ms. Fee.
Thank you. Thank you for your time today.
Thank you. I'd now call Mark Alexander forward, the Rolleston Residents Association. Welcome, Mark. You know the rules.
Kia ora. I'll just get set up. Just bear with me just a moment. The previous speaker just a little bit longer than I expected. Tēnā koutou. Ko tako ingoa ko Mark Alexander oho. Ko ao te whakahere o te Rolleston Residents Association. Hello, I'm Mark Alexander. I'm chair of the Rolleston Residents Association. I'm not here today to harangue you, harass you, or ask you to do something difficult or unlawful. I'm here to ask you to help our community and our residents. I'm not here to comment on the merits of any particular liquor licence application. I'm here to talk about the process. I'm here today to ask you to do something simple, to expand on the legal minimum that council does in the liquor licence application process. Some background. Have you ever wanted to prepare a submission on a liquor licensing application in our district? As a councillor, I hadn't given much thought to the process and how easy it should be for our community. On council's website, there are the alcohol licensing public notices page, which lists the applications lodged with councils which people can submit on. Each public notice reads, Public Notice, Section 101, Sale and Supply of Alcohol Act 2012, the purpose for the application, and that the application may be inspected during ordinary office hours of the Selwyn District Council Licence Committee, Care of Food and Health Standards, at Level 1, 110 Mandeville Street, Riccarton. And you've got 25 days from the publication of that notice to make your submission. That all sounds fair and good, but it isn't. Let me share my experience in preparing a submission on behalf of the Rolleston Residents Association. The application may be inspected during ordinary office hours at 110 Mandeville Street. The public notice is one that has to go to Food and Health Standards Riccarton. You can't view the application in the Selwyn District. You can't view the application in the district where we live, where our community is, where the proposed business will operate. A potential submitter cannot get a copy of the application. You can only inspect the application at 110 Mandeville Street. I wasn't allowed to do anything more than view the application and make notes. I wasn't allowed to copy or photograph any pages of the information of the application. 110 Mandeville Street is 21 kilometres from here, 20 via State Highway 1, 23 via the motorway, about 20-25 minutes drive. It's 42 kilometres from the Darfield Bakery, 41 from the Leaston Library, 143 from Arthur's Pass. Having gone to Food and Health to view the application, I was told I could have made an appointment with Malcolm Johnson, the Chief Licensing Inspector, who would have brought the application for Rolleston to me to view. However, Council's public notice doesn't tell you that, and I still would have only been able to view the application. It's hard to prepare a meaningful submission when one can only view the application on a limited amount of time and not get a copy of it. Food and Health staff said that I should make a simple submission in support or opposition of the application, indicate that I want to speak to the hearing, and elaborate on my submission at the time of the hearing. They noted that I would receive a copy of the application prior to the hearing, which I now have. I would rather have made a better initial submission with access to the application. The full application can be obtained with an OIA request, but given the 25-day submission period, that's fraught. You'll not like to get your response in time to make a submission. Is this an adequate or acceptable process? No. Can we, council and community, do better? Yes, we can. A liquor licence application is similar to a publicly notified resource consent application. People can make submissions on the application. In both cases, the information and application are in or should be in public domain. However, in the resource consent case, all the information is available on council's website for reading, copying and downloading. In the liquor licence application case, none of the information, except that an application has to be lodged, is available anywhere for reading, copying and downloading. None of the information is available. The legal minimum, and I've checked the Act, is to have the application available for viewing at Food and Health standards at the east end of Riccarton Road. If you don't live on or near a bus route, you would have to drive during business hours to Mandeville Street to view the application. How is this simple or easy for our community? Is there a legal impediment that prohibits the publication of liquor licence application? No, I've checked the Act. This is information that should be freely available to our community and residents. Section 101 of the Act does not prohibit, I repeat, does not prohibit or prescribe against the publication of the application information. It was suggested to me there might be grounds of privacy for the applicant. Well, redact personal details. But the application itself is public information which affects our community. My request is quite simple. Let's do more than the legal minimum. Simplify the process to help our community more easily participate in the liquor licence application process. Publish liquor licence applications on the council website. Redact personal information if necessary so that anyone may view them at any time. I've discussed this with Malcolm Johnson, council's chief alcohol licensing inspector, who indicated that he agreed with me. He thought that council should publish the applications on council's website. And I did ask Malcolm if I could quote him. Tēnā koutou katoa.
Kia ora, Mark. Thank you for your submission. Do we have any questions, councillors? It seems you've been very succinct as usual, Mr. Alexander. This will be followed up in due course. Thank you for bringing this to our attention. We now have public forum from Barry Hopkinson from Tui Estate. Just make yourself comfortable and press the button on the right of the microphone when you wish to speak. Thank you, Barry. Just please push the button on the right-hand side of the...
Keep it down.
That's it. Yes, perfect.
Good, thank you. Again, Mayor and councillors, I appreciate the opportunity to be here today. I prefer not to be here, and you'd probably prefer me not to be here either. I circulated a submission as I realised that 10 minutes was not a very long time for me to say what I wanted to say. So I'm going to take it that that submission has been read, and I suggest that we go straight to maybe the conclusion when I can add some further points. Is that agreeable, Mr. Mayor?
That's perfectly agreeable. We have received it and read it. Thank you.
Well, having read all the details of that submission, I ask the councillors the following questions, which again are there for them to read, but I'll read it out. Do the councillors accept that advising a substantial ratepayer that their development is effectively abandoned through the advice of another party's consent By that, as you realise, Tui Estate had no formal notification from the council that their consent had lapsed. We received a second-hand notice because a applicant had applied for a consent on a property that we'd sold them. And the building consent was approved, but the consent to build on the site was said it had lapsed. Do the councillors think it's acceptable that the council had clearly done no research or taken advice from their legal advisors before taking the stance that the consent had lapsed? It became quite clear later on that they had not. And it was only when we actually submitted the MTP case that they actually submitted or had any contact with their solicitors. Do the councillors find it acceptable that the council were not aware of any recent case law by the Environment Court ruling that would have proved the council's incorrect opinion was an error, with the council stating that there was limited precedent? The MTP case was in late 22. This case started in early 23. So the MTP case was only 5 or 6 months old, and it occurred on the West Coast. And it was an example, it was a development which had, from the West Coast Council, had their consent lapsed, and the Environment Court ruled that it had not lapsed. Do the councillors agree with the fact that the council supported that the ruling was, in inverted commas, a judgment call, and previously quoted, and either call could have been wrong, despite recent case law, which suggests that it was something of a toss of the coin? Why did they call and choose the result that effectively abandoned the whole project? Not only an abandonment of future sales, but a write-off of the substantial ground and water rates paid and the maintenance of the project since 2010, in an not unreasonable expectation that in future all lots would be sold and built on? And the last question is, do councillors feel that it is equitable that a substantial ratepayer should be forced to incur consulting and legal costs to correct a wrong not of their doing? The rates currently being paid on this property is about $26,500 a year. And I estimated yesterday that it's probably over 200,000 since this consent was granted. And I propose to councillors that the actions taken by the council are utterly unacceptable, and we seek reimbursement of the costs of which are outlined in the appendix 4, that it was one of the appendices that would attach to the submission. And I guess I'll leave it open to council for questions.
Thank you, Mr. Hopkinson. Any questions from councillors? There don't appear to be any.
Right.
Oh, sorry, Councillor Munt, you've come up late. Yes.
Thank you for bringing this to our attention, and I just want to offer my condolences in what's taken place, and I hope that we will find a solution and a
You
remedy.
have a question, councillor?
Sorry. Question. Thank you for coming, and that I'll end there.
Thank you. Chief Executive, these matters brought up in public forum will come back as a report at a future meeting. Thank you. Thank you for coming along today and embellishing your submissions, which we have received. We've got the message loud and clear, and we will have a discussion at some stage over this issue.
Could I just make one further comment? It would be remiss of me not to come along and propose how we might settle this matter. And there appear to be two options. One, you pay the invoice now in full, or you give us some rate rebate or rate holiday for a period of time to reflect the costs that we've incurred bringing the council to account.
Thank you for your suggestions that I've taken on board.
Thank you.
Thank you for your time today. Now we have the Melbourne Community Board to come and have a conversation with us.
Thank you.
Right, while my more active member of the community board just distributes a manual copy, I'll just explain a few things. Bruce is handing out a hard copy. I'll explain the blank front page. So the front page is blank, everybody. We have provided you all with a hard copy in case we have a global IT outage, which does happen, power failure, or even the internet falls over. We've also provided you with a blank sheet of paper so that you can borrow a pen from the council or from me. I've got one here spare if you need. And respond to the representation, review, consultation, even if you do not have email, even if you do not have a computer, you'll be able to do it, a smartphone or reliable internet. So let's hope that we can have a manual feedback route for the representation, review, consultation, just like we have for the future Selwyn consultation document. That's the front cover, everyone. It's right there out there now. Please submit. The back cover's got a manual form that you can put in. So I'd love to see that. We as the community board would love to see that. Okay, so I'll introduce Bruce Russell, our chair of the Malvern Community Board. And I'm Calvin Payne, one of the community board members for Malvern. So thank you for the opportunity to present our views on the initial and formal consultation process for elected representation for Waikirikiri Selwyn District. This is the view of the Malvern Community Board and is based on feedback that our members have received from the Malvern and the wider Selwyn community, including our local residents groups. We understand the council has before it today the opportunity to confirm the formal consultation process as part of the representation review process. We do not support either of the current options in the preliminary consultation, as we do not believe either provides effective elected representation in Selwyn District. In particular, for our rural wards of Ellesmere, 900 square kilometres, and Malvern, 5,000 square kilometres. To be clear, the current cost of the Malvern Community Board of 5 people has only increased by 4% this year to only $25 per ratepayer per year in the community board area. 56% or $14 of that $25 is returned straight back to Selwyn District Council as a support cost. The value of this support cost is currently $110,108 for the 24-25 financial year. After remuneration costs are taken into account, this only leaves the board under $30,000 per year for operating costs for 5 members to cover 5,000 square kilometres. We are currently under another representation review process, primarily because Rolleston Ward has expanded and Ellesmere Ward has reduced in population outside of the guidelines. As the fastest expanding region in New Zealand, this situation is likely to arise again in the near future, and we should endeavour to make any solution resilient for the future. We understand that elected representation is normally allocated on population alone, although there are some exceptions for large, sparsely populated rural areas. The ward areas in SDC are currently allocated elected representatives as follows. Rolleston and Springs Ward have 3 councillors each. Each councillor is responsible for approximately 100 square kilometres. Ellesmere Rural Ward, 900 square kilometres, currently has 2 councillors, each of who approximately cover 450 square kilometres. Malvern Rural Ward has 5,000 square kilometres, has 2 councillors allocated each covering 2,500 square kilometres. Of course, in Malvern, we have the community board of 5 members, so this decreases the 2,500 square kilometres to 700 square kilometres per elected member in Malvern. In the current option being presented for the formal consultation in August, 8 councillors, 4 wards, no community boards are as follows. Rolleston and Springs essentially unchanged, although West Melton is added to Springs. They have 3 councillors again in each and 100 square kilometres each. Ellesmere Rural Ward, now 900 square kilometres, as we said, 1 councillor now. That means that's 900 square kilometres for 1 person to cover. Malvern Rural Ward, 5,000 square kilometres, no community board, 1 councillor who needs to cover 5,000 square kilometres. Our view is that if the current option is enforced, then the only way of ensuring continued effective elected rural representation would be to maintain the Malvern Community Board and even increase the number of members. The establishment of a community board in our other large sparsely populated rural area of Ellesmere should also be considered. As a relevant comparison, our neighbouring council, Waimakariri, has a 69,000 population, only 2,200 square kilometres of area, and the main elected representatives are 10 councillors and the mayor. It also has 4 community boards with a total of 24 additional elected representatives across the district. Waimakariri has a similar population, a third of the area and the same number of current councillors as Selwyn District Council. Each councillor on average covers 220 square kilometres. And elected members, if you include the 34 in total, which is 10 and 24, it's only 65 square kilometres. The preliminary consultation, in our view, the preliminary consultation that has already occurred, in our view, resulted in 80% of respondents, both electronic and hard copy, confirming that they would like the Malvern Community Board to continue. This percentage is based on the 229 electronic responses, of which 107 had no location reference, the 247 hard copy responses from Malvern Community Board and Darfield Residents Association, and the 75 from the Kirwee Community Association. Our view is that the formal consultation in August should include relevant options, clear open questions, and encourage written feedback. The feedback also needs to be received by all available methods, including online, including email, including hard copy, and in location recorded when possible. It would also seem appropriate that consultation is widely advertised to ensure as much feedback as possible. The Local Government Commission provided determinations in 2016 and 2021 regarding the effective representation in the Selwyn district, in particular regarding, this is a quote, the Malvern Ward vast geographical area, and the effectiveness of community boards providing rural representation. We have attached hard copy extracts for your information on the back of our document, and we will be providing a full email copy of those determinations so you can see it in full detail. We would like to encourage the council and councillors to present reasonable options to the community in this formal consultation to provide us all with effective elected rural representation for Selwyn district into the future. Thank you. And any questions?
Thank you. Any questions from councillors? Councillor Munt.
The representation review consulting clashed with the long-term plan. Do you feel the timing of this has impeded the wider results and feedback from the communities in any way?
Yes, we discussed this at length. They were in fact, they didn't clash. They were exactly the same opening dates and closing dates. So the long-term plan was very important and is essentially determines the rate rises and very important to everybody. We had a record response on that, but we had a very small response, 249 and 229, I believe, on the representation review. So it was unfortunate that that was only the initial representation review consultation. So this is the formal one that's coming up, and in August we get the opportunity, and we need to make sure that that is advertised adequately, and we will be ensuring that as Malvern Community Board because the community have asked us to do that.
And the second question was, as a group, have you considered the fact that it might be advantageous to reduce the number of councillors because that will then effectively provide a better payout for the future councillors, and therefore you'll get a potentially more people putting their hands forward to run for council?
We have considered that, although in our rural wards of Ellesmere and Malvern, we consider that it's more important to have numbers of people out there on the ground who can advocate for communities, can go to communities rather than using unreliable internet as we try to in rural areas. And we consider that it's more important to have more people, and we can have those larger numbers by having an efficient value for money community board in both those areas.
I guess as you're tasked with representing the views of Malvern, you haven't really touched in this on the number of councillors in the Malvern ward. And so I just wonder if you have any thoughts on that.
Yeah, I tried to, but maybe I didn't make it clear. Yeah, our views is that currently there's 2 councillors in Malvern, and I believe the Malvern Community Board provides support to those councillors in an effective and valued way. But those 2 councillors have an enormous area to cover, and to physically go to every meeting would be really difficult for those 2 councillors. It's 5,000 square kilometres. It's 125 kilometres from West Melton to Arthur's Pass. So the number of councillors, I can, Bruce will tell me if I'm not representing the community board views, but our view is that 2 councillors is the minimum we should be having in Malvern, if not more. But obviously the area is the restriction and the population is the restriction at the moment. So we could do that with value by having a community board to back up the councillors.
Thank you, Calvin.
Thanks, Lydia.
Councillor Hassan.
Thank you. I've got a query over the catchment areas about how they keep moving to fit in with the population requirement. And you've mentioned in your submission about West Melton being transferred now from Malvern community into the Springs ward. So, but you're only advocating for community boards for those that have 2 and the 1 councillor each in the under the representation review. So my question is, why are we not looking at all 4 catchments having a community board representative if you're going to have the catchments constantly being altered or changed?
Yeah, a great question, Deborah. We believe that community boards would be a good option in all wards, and I agree with you on the when we keep changing the ward boundaries and we're moving populations around, we need to, as I said at the very beginning, we need to have a solution that's can be resilient for the future, so that when the ward changes again, which they will because we're expanding, we need to get to the point where we can have community boards in every area if that would be the most appropriate and efficient way of doing it. And would advocate for that. It's just highlighted at the moment in the 2 rural wards of Ellesmere and Malvern because of their large geographical area.
Thank you. Councillor Miller.
Good afternoon. I just want to be clear on what your public forum is asking us today. Are you asking us to amend the report in today's agenda around disestablishing the Malvern Community Board, or as I think you were doing, I think you're lobbying for us to have an effective consultation process once this is passed, that everyone's enabled to actually submit in a meaningful way.
Ideally, it would be good to amend the recommendation, yes. Although what we're really advocating for on behalf of our communities, because that's what have told us, is to make sure that the formal consultation has some very open and honest questions that we can respond to. So it doesn't say, let's not go back to the initial one because that's obviously passed and the results are in. But just so that there's a question that says, do you believe there should be community boards? And don't ask the question just of Malvern as well. Let's ask the question of everywhere. Should there be a community board in Rolleston, Springs, and in Ellesmere particularly, but also in Malvern? I mean, we need to ask that question of everyone, not just the rural boards and the rural wards. Thank you for your question.
Right, thank you very much for your presentation. We've got your message. That brings us to the end of the public forums. Thank you for participation. We will now move on to confirmation of the minutes. We have before us the minutes of the ordinary council meeting of Wednesday, the 12th of June. Can I have a mover and a seconder? Councillor Mugford and Councillor McInnes. All those in favour say aye. Against? Carried. Thank you. We also have the minutes of the extraordinary council. I'm sorry, councillor, they've been passed. What is your correction?
Correction is on page 12, where it says moved as amended, councillor Hassan, seconded councillor Munt. I think you'll find that it should actually refer to councillor Miller and councillor Hassan, who actually moved the original motion with regards to the public initiated waterways closure.
I'll leave staff to rectify that should it need to be rectified. Thank you very much. Right, we'll now move on to 5.2, extraordinary council meeting on Wednesday, the 3rd of July. Can I have a mover and a seconder, please? Are you going to move it for me, Deborah? You've got your light on.
No, because I have a matter of
Moved councillor Hassan, seconded councillor Epihar. And you have an item to speak to on that, councillor Hassan. Yes.
page 18.
Page 18. 323.
In which Mr. Harris has noticed under the big changes, the mountains to the sea cycleway has not been included in this LTP. So I'm just want a clarification around that because I'm sure our ratepayers would be very pleased to know that we have just made a saving of $27 million if this project is not to go ahead.
I think that's a typo. From my memory, the previous LTB had $27 million and we drop it down to 5.
Correct, yes, yeah.
And
We
it
definitely did
but
fund 27.
it doesn't mention the 5. It actually says mountains to the sea cycleway has not been included in the long-term plan. Decisions were made to complete the rates review, etc. But it's quite clear that that's what it said was not included in the long-term plan. So.
Well, yeah, we'll have that sorted. So any other corrections? All those in favour, please say aye. Against? Declare it carried. Now, councillors, we've been listening for the last hour and a half. I think we'll have a quick 10-minute break and then we'll get into the rest of the business. Councillors, the next item on the agenda is tab 6, Upper Selwyn Huts Engagement and Consultation Proposal. Manager Harris, the floor is yours.
Thank you, Mr. Chair and councillors. I'll just walk you through the report and then take some questions at. So the purpose of this report is to seek agreement from council on a proposed approach for engaging consulting with the Upper Selwyn Hut community to develop a proposal for the eventual removal of the Upper Selwyn huts. I do note that that purpose was discussed during public forum, and I'll come to discuss aspects of what I actually mean by removal and find out later in the report. Significance. I think this is a significant decision. That's the view that we have reached. We have received a lot of correspondence, questions and Lagoima requests. It's become clear to me as I've engaged with the Selwyn Huts issues over the last 6 months that this is a significant decision for that community, and especially through the potential loss of their homes. So as I say in this report, I think it does require a full consultation process, and this will allow the community a degree of certainty about when people can expect to be informed of a proposed council action and when and how the community can expect to have direct opportunity to contribute to decision making. At point 3, excuse me, I have laid out a bit of history and background. I won't go over this in detail. It did form part of the March report of earlier this year. I will say one of the things that I don't probably tease out here clearly, that there is a clear trend over the number of years for the huts being occupied on a permanent basis, and this is accelerated post-earthquakes. So 96 huts, most of those are now in permanent habitation. Just navigating my machine, which seems to stop working. So at 3.3, I discussed the situation with the WWTP, that's the wastewater pipe, and the current deed of licence. The deed of licence has been extended to the 30th of September 2024. In an earlier draft of this, I had the wrong date actually, so if anyone's got an older copy, I had the 26th of August. It has been extended a couple of times, and it is the 30th of September. As we know, the consent, the current consent for discharge to Land and Water expired in 2020, and currently we're under a continuance from ECAN on that old consent, on the expectation from Canterbury that the current construction works for the new wastewater facility pipe will be completed in the near future. At 3.31, I start just laying down a bit of a timeline of the earlier council decisions, and you can see them laid out there, and I won't go through those in detail. At 3.37, a line has actually fallen off the page for some reason, and there should be a 3.38 saying that on 13 March, Council passed the following resolutions, and those resolutions are included in italics below that, that section. Since that time, as I just said before, the existing deed of licence has been extended twice to accommodate the current process, with the latest extension set to expire 30th September 2024. So moving to the discussion, as I said before, since the March meeting, the council has received over 200 individual queries and local government and official information meeting act requests concerning the Upper Selwyn huts. Many issues have emerged from these, but I've just highlighted some key ones. There are grave concerns from the community about the potential loss of their homes and the emotional and financial impact that this will have. As Claire pointed out in the public forum, the Upper Selwyn Huts community are extremely concerned about the procedure followed by the Selwyn District Council in relation to the March meeting in particular, and the limited opportunity it gave for that community to engage with the outcomes and the options that were put forward in that report. There's also been a lot of concerns put forward by the new deed of licence. What has emerged too from my answering a lot of questions and inquiries is that there is a perceived inconsistent and in some cases a real inconsistent advice that has been received by the Upper Selwyn Huts community during in particular the DOL, the deed of licence assignment processes, and that's when huts changed hands. I have a small section on legal advice at 4.3. And Council's decision in relation to the Upper Selwyn Huts were originally based on the premise that any future DOL was to have a finite and short-term life. And these decisions were made in the context of an uncertain wastewater system. This uncertainty has to a large extent been resolved. And I've come to a view that at least elements of the Upper Selwyn Huts community may have considered that this changed the basis for those decisions, and therefore the legal advice is now indicating it now may be appropriate for Council to follow a fuller consultative process in relation to DOL decisions. At section 4.4, I discuss the WWTP pipeline connection. And if you recall, there was a decision made at that time that 30% of that extension down to the huts would be paid by the Upper Selwyn Huts community over a 15-year period. Under this proposed engagement process described below, it will not be possible to collect this portion as a new DOL, deed of licence, will not be in place and its terms and contents will not be finalised until this consultation process has been completed. However, this is currently the case under the existing process, as we wouldn't have a new deed of licence put in place until later this year. At 4.7, I discussed the licence fee of $1,389. And invoices for the forthcoming year are due to be sent out soon in August. So we know that under previous council's decision, council decisions, that the Upper Selwyn Huts community will not be included within the district-wide rating systems for water or sewage. And one of the main reasons for this is the uncertainty of the solution required for the Upper Selwyn Huts. And as I said before, this uncertainty is now largely gone. I've just got in there that if the Selwyn Huts were added to the district-wide rate for sewage, that would increase approximately $14 to that rate per annum. Now, I'm not suggesting here that this should be the case, but what I am suggesting is that I think that the discussion of the quantum of what the Upper Selwyn Huts people pay for the wastewater pipe should be up for discussion, as should the discussion around whether they should be included in a district-wide rate. The next section, 4.9, I discuss the compliance issues. And as we know, the licence to occupy is on a fairly small block of land, about approximately 200 metres. So they are fairly close to each other. In my view, they were never intended to be, to have that layout was not intended to have allow permanent habitation. So there are some, I guess, unique situations at the Upper Selwyn Huts in terms to compliance, health and safety. We have received legal advice that we have legal obligations, both as a regulatory authority and as administrator of the huts to that community in terms of health and safety. And accordingly, I'm proposing that we do move on with an inspection program of the existing huts. Now, I should add, and I understand there may be a low trust environment between the hut owners and the council, but this is really about working with the hut owners in terms of coming up with ways of having solutions, making sure nothing's terrible is going to happen. So that's the intention of the inspection program. And I've got Mark here perhaps to answer questions as we reach the end of this report. So number 5, I set out the proposal, and in broad terms, it is proposed to follow a process of community engagement to develop a statement of proposal, which would then be subject to a consultation process. I've included an indicative timeframe. It is very tight. I would suggest that if the scope is broadened, that these timeframes may be difficult to meet. One of the reasons I thought having a July 25 end would be good is that then I guess it's the start of the financial year. We wouldn't have to try and prorata any license fees, and it's quite a nice way to, if they were in the district rate, to have that rate system tied up when we do that sort of work at council. But look, it's not the end of the world if we go over timeframes. I'd sooner do a thorough job rather than try and meet artificial timeframes just to meet statutory compliance. We can extend things out if we need to. .3, I talk about the scope. And we've heard from the public forum that this is an issue of contention, and the council may want to discuss this. They probably will. But I think it's pretty essential that we clarify the scope of what's to be discussed fairly early on in the process. And I say that it needs to be understood by all that the council has decided that at some point in the future. Now, I'd just like to expand on that a wee bit. I do say at 5.4 that we're open to innovative approaches. And I thought about this a great deal. And I wanted to tease this out through the engagement process, but it may be that the term of the deed of license, if that is the mechanism we used, isn't timed to a time frame, but is tied to to triggers in the environment. So that is something we could think about. I should say I have got Monique Eade here. Monique Eade was the person that was involved with the Huranui solution that looked at that type of mechanism to help the residents down at Amberley Beach. But anyway, I think the scope needs to be agreed to early on in the process, and that should happen right at the beginning. So at 5.5, I set out the engagement process, and I worked with Monique in terms of her experience at Amberley Beach to develop this. We're suggesting, and this is a draft engagement process, and certainly I think we'd get some input from the hut owners about what that looks like. But what we're talking about is 3 sessions at least, for using an independent facilitator, and you see what we're talking about in those 3 sessions. I think also we'd be prepared to have individual meetings with property owners or groups of owners as required. At 5.7, while it's unlikely that these sessions will result in total agreement across stakeholders, it is envisaged that all views will be heard with the hope that some common ground might be found. I do say at the end of that paragraph, and I think it's an important sentence, whatever happens, I think it is imperative that the ongoing management of the huts in the future needs to be more structured and intentional than it has been over the last number of years. So following these sessions, the council will draw up a statement proposal, which will be subject to a full consultation process involving public notification of a statement of proposal, a submission process, then a hearing for those hearing for those submitters that wanted to be heard by council. And I'd suggest that full council would be involved in that hearing. There are a number of key stakeholders, and we will be keeping those stakeholders involved and informed as we go through the process. At number 6, I put forward 3 options. I won't go through those in detail, but the first one is a do nothing option. This isn't seen as practical. The second option is to continue with the current process, and as I said before, that is not staff's preferred option. The preferred option is for council to pause the current process and embark on the engagement and consultation process described in section 5 of this report. Funding applications at number 8. There are some short and long-term funding implications, obviously, for the decisions. The current position of council is that the Upper Selwyn huts will contribute 30% of the cost of the new pipe for the next 15 years. Having said that, under the current process, our council would not have a DOL in place until the end of this year. So on that basis, the lost revenue is in the order of $60,000 until a new potential DOL could be put in place at the beginning, the beginning of the next financial year. There is some staff costs in terms of the inspection. It's been estimated at $41,500. The process itself, in terms of an independent facilitator and consultant and other bits and bobs, would probably be in the order of $100,000. That is a guesstimate, really. So that was just finger in the air, but I don't think it's too far off the mark. And 8.5, I include a table of those costs. I should point out that these aren't really strictly additional costs. The process that we are in is costing a lot of staff time and money and resource and legal fees. So this isn't on top of, it's a bit of instead of, so there might be a bit of extra, but certainly over the last 6 months, we've had an inordinate amount of staff time and legal advice and other consultants helping us out with the large number of queries to the process. Look, at 9, I talk about reputational issues and communication. Look, I think that it's imperative that the process is transparent, that the community is well informed, that they're supported, and they have engagement with the process and feel involved. And to that end, part of this engagement process will involve a communication plan. Look, I'll end it there. Happy to take questions, and I have Vanessa from the building perspective, Monique from the previous experiences at Huranui, and Mark Olin, our legal advisor. Thank you.
Thank you, Mr. Harris. We've heard from hut owners representatives today. They're very concerned about the inspection and people being left homeless. You've mentioned a few moments ago that that was not the intent of the process to undertake these inspections. Perhaps our legal representative can tell us why we need to do this and give us a bit of a background, please.
Yeah, thank you, Mr. Chair. Yes, the council's wearing two hats here. It is obviously a building authority and also has regulatory obligations under the Health Act, which I'm sure the councillors are all familiar with. In addition, and this is slightly more unusual for the council, it is effectively a landlord and the administrator of the Selwyn Huts area. The first hat, if you like, the first set of the first role doesn't carry a lot of obligations, but there certainly are a number of powers, and arguably, the council has a duty to make sure that throughout the district, dwellings and premises comply with the various statutory regimes. So that's only arguable, and the council's not usually liable if it doesn't do that. However, the council definitely will be liable, and potentially senior staff, not so much elected members, but senior staff could be personally liable if the council doesn't take steps to under the Health and Safety at Work Act. So safety and it should be something that the council considers, and I'd suggest it should be pretty high up the list of things that are considered in this context.
Thank you for that. Thank you for that. Mr. Harris, you mentioned the scope. Just interested to know how the scope will be determined.
Well, I think in the first place that we through a discussion with the hut owners, but this is my view. I think the council will have the last say in that process. We'll listen, consider the views put forward, but ultimately I think it's the council's decision to include what scope. But as I said before, my intention is not to stick to the tried tested formula in terms of a deed of license and a time frame. Other options may be available, and quite interested to explore the Hiranui option. So while I talk about a finite being out of scope, I think there's innovative ways you could define finite and move around that issue.
So you're looking to be flexible with the engagement and the consultation?
Yes.
Okay, thank you. Councillors, questions? Councillor Munt.
I would like to move an amendment to G and change the word from undertake to engage on. G is during the consultation period, the council will work with the Upper Selwyn Huts community to engage on an external building and lot inspection of the existing huts and any other associated structures to determine compliance with relevant legislation, with fits with what you've said, Tim, about working with the community over this inspection process. And if I can speak to a little bit more, I'll say I just feel like we need to go back to the drawing board on this, because the community have said to us today about their lack of trust, and they had very valid reasons for that. And I think it would be appropriate.
I think we need to get a seconder before we carry on any further with
Certainly.
this discussion. Do we have a seconder for this amendment? Councillor Mugford is seconding the amendment. Okay, Councillor Dean.
Got a point of order, Mr. Chairman.
Point of order?
Can I be heard?
Yes.
I believe that on the 13th of March, this council had a vote and set a path forward. Some of the recommendations made in this, the recommendations by this latest report are contrary to those decisions that were made on that day. And while section 27.7 of our standing orders addresses this from going from a defeated motion to when you can put a positive motion back on the floor, I believe the spirit of 27.7 is the same thing, that we cannot revisit where there is an obvious change in direction without a process being followed about rescinding our previous decisions. That's my first point. Second point is I believe that Councillor Munt's amendment can't be made until we have a substantial motion for all of the recommendations first. So I think that there are the 2 points there. Thank you.
Yes, I accept your comment about Councillor Munt. The first point I need to investigate. Chief Executive.
Yeah, well, I'll just ask Shiraz to look at the standing orders, but I think you might be along the right lines, and it may well be that a decision could be made today to rescind.
I believe that, if just to speed things up, it says that 1/3 of those people who have to sign a document saying that they agree to rescind that previous document.
If you could just, if you could give us 5 minutes to pause just to.
Okay, we'll just
assess.
adjourn for 5 minutes, chat amongst yourselves. Commence. Councillor Munt, please take your seat. Right, we have a determination on the point of order brought by Councillor Dean, Chief Executive.
Yep, thank you, and thank you for those few minutes just to have a look at that. 27.7 doesn't apply in this instance. Yeah, it is when a motion has been considered and rejected, that's not applicable.
That's all right.
Thank you. Thank you. So I do believe, though, we, as previously pointed out, that we, in order to have an amendment, we need to have the substantive motion put. Therefore, is anybody willing to put the substantive motion? Councillor Epiha.
Tēnā rā tātou katoa. I just have one question, Tim. Sorry, I've kind of just lost my train of thought there. Are you confident that the recommendations put today clearly address some of the concerns put by the Upper Selwyn Huts and also clear the information that Claire's brought to us? Sorry, I'll start that again. Are you confident that the recommendations that are put to council today address the opportunity for the recommendations that Claire has put to the council today?
The majority of them, yes, not all of them. I think we differ on the inspection program and but I think in terms of the resolutions that she was suggesting, they're fairly consistent other than that one. There's some other issues in terms of the scope, which we distance apart, but that's pretty close. I'd say 85–90% there.
On that basis, Deputy Mayor, I'm happy to move the report.
Thank you, Councillor Epiha. Moved by Councillor Epiha, seconded by Councillor Dean. Thank you. It's now been moved and seconded. All of those in favour, or we'll have some conversation. Sorry. Yeah. Councillor Munt.
Sorry, Mr. Lau, but I'd like to ask when I put my amendment forward. Now, sure, thank you. I'd like to move an amendment for G to change the word from undertake to engage on, please.
And seconder is once again Councillor Maitland. Any discussion on the amendment? Councillor Bell.
I support the thrust of the amendment. I just wonder whether it catches what we're going to do, because it's sort of, I think a bit, if you would permit me to, so perhaps we should change it to determine and undertake an inspection process, because it's sort of engage on, it's very vague as to what we're going to do.
Amendment.
But it's only with the permission of the original mover for that to happen. Engage on, have determined.
Yeah, I think the determine sounds as though that we're not working with the hut owners on that determination. So you're talking about engage on and determine, as is written here.
What he says, that says the consultation period, the council will work with the Upper Selwyn Huts community.
I think it's important that we're including the community in the discussion process prior to the inspection. I think that's the whole thrust of what I'm aiming to achieve here with this, so that we can build that trust and work in a collaborative process, because they're not underhanded and not undermining the community's ability to work with council to move forward. And I think it's going to give us a better outcome all round and not open us up to litigation.
And just for clarity, when we say external, we're not meaning an independent third party. We're talking about the externality of the building.
You say we talk about an external building inspection.
So it's not an independent third party.
Oh, sorry. Yeah, that's right. No, we've got a team here that's going to do it.
For clarity purpose, it is the council team that will be doing it, not an external buildings company. That's correct. Yeah. Thank you.
Okay, councillors, we're discussing the change to the original motion. Representative Mackay.
Yes, so I wasn't going to talk to the paper as such. It was to Tomitu's engagement in this. And so did you want that to be at the end?
Yeah, that's probably easier a bit later. Yeah, thank you.
So
Okay, so then I have councillor Hassan.
My clarification is around G with regards to undertake and engage on. Going to the body of the report, we talk about the inspection program and we quote a figure in 4.10 and 8.3. I'll combine them for health and safety of $41,500, right, with regards to this inspection process. My clarification, and it's not mentioned up there, is who pays for this inspection program and any remediation? Or is that to be part of the consultation process as well? Because I think we need clarification that if our ratepayers are going to pick up all of these costs of remediating any works that needs to be done on the consultation process, then a dollar amount needs to be understood as well.
Mr. Harris.
Yes, no, thank you for that question. The $41,000 is for the staff to undertake a inspection and write up a fairly basic report. Any remediation would be up to the hut owners, and certainly the building team might give them some options. We would not be expecting our ratepayers to pick up the repairs to the huts themselves.
Councillor Glidden.
I support what Elizabeth's trying to do here, and I just, for the sake of trying to not make things too difficult, I'm just trying to look at that and see clarity in it. And so I had just written down here that it might, I guess in my mind, it looks like agree to consult with the Upper Selwyn Huts to develop an external building and lot inspection program of existing huts and associated structures. To just be clear and concise about what we're trying to say. I don't know. Is that what you're trying to say, Elizabeth?
I'm trying to say that this is a two-way conversation between council and the community, but proposing this and agreeing upon a solution before we go ahead with an inspection program.
Yeah. I don't know if you want to use that or not, but I guess it's got the same essence. So I support it.
Okay, right. Councillor Ebihar.
As the mover of the report, tēnā rā tātou katoa, mihi ana ki o katoa te tangata o Upper Selwyn Huts. And as the mover of the original, the previous report, I felt compelled to maybe share some kōrero, if that's okay. We've discussed the cost of doing it right as the cost of what it should have been in the first place. I apologize. I just want to acknowledge you all, truly, and the folks of the Upper Selwyn Huts. I want to acknowledge your hurt and the process that you've gone through because of the decisions that have been made. At the risk of being a human weather vane, I've actually written it here so I don't get mixed up. Responsibility of council is to make decisions on the facts and the law, and best advice from our council made with good engagement in the best interests of equitable outcomes. Today, I hope we by adopting this, we begin again with pause. I think the motion today strikes a balance to pause and reassess.
Councillor Ebihar, we're discussing the amendment at the moment. Are you?
Oh, sorry.
Are you aware of that? Or do you want to?
No, I was.
You should write a reply. You want to save that till after the amendment?
Roger.
Okay.
Yeah, all good.
Okay. So any more discussion on the amendment? Right, there'll be no more discussion on the amendment. I will put the amendment as is above you on the paper. All in favour, please say aye.
Aye.
Against? The amendment is carried. We now have the substantial motion with the amendment. Councillor Ebihar.
Thank you. Well, I just wanted to acknowledge you all actually, and when I hear things like you don't want us to live here and there's no trust, it's certainly not why I took up this position as a councillor, to represent my community, to make people feel like that. So hopefully today is the start of a process that we can do things right and include our community. I just really wanted to finish by reading out a little piece of submitter during the LTP. His name is Nico Te Ngaru. And he said, I'm a kid at the Selwyn Huts. I love living here because I have lots of friends and my mum and papa do too. My grandma lives here and I love her to see her every day. I'm really sad that you don't want us to live here anymore. He goes on to say that he cries a lot and that we should think about it. And I think today we have with being confronted with the facts, and I appreciate that. So thank you, Nico. Thank you to all of you that have turned up here today to show us that, and I hope that we continue on this path to build that trust back. Kia ora.
Kia ora. Kia ora. Any more questions? Otherwise, I'll put the motion as a substantial motion. Oh, Councillor McInnes, my apologies.
Yeah,
I'm Megan, yes.
so I would like, if anyone wants to support it, to make another change, if possible, another amendment. Because in C, I do not think that till the 1st of March is long enough for a consultation on the whole community. I think for D, that's probably appropriate because that if there's any changes, then we can put that through in an in an annual plan. If there's any decision around something like the district-wide rate for sewerage. But as far as the DOL is concerned, I personally don't think that that will be enough time to gather all the information and actually have out enough discussion and back and forth around legalities and futures and potential anything. So if possible, I would like to, it would be good to have an end date for it. However, I don't think, I'm happy to take suggestions on what an appropriate period of time. Do we go for 12 months or 18 months? Something like that.
Mr. Harris, you mentioned earlier that you really thought that getting something through by July would tailor in quite well, but you had flexibility in your thinking.
Can I just seek some clarification, Mr. Chair?
Yes, certainly.
So the process is going to start with an engagement process, and I wanted to try and fit that in the first half of this year, and then over Christmas and January, February, develop that statement of proposal, then go into a formal consultation process at March with the view to getting through that, which is the submission and hearing process by and a decision by the beginning of the 25 financial year. So, and I say that because some of the financial implications that may flow out of the new deed of license, that is what we use, will need to coincide with a beginning of the financial year. Otherwise, it's going to get, it's not impossible, but it does get messy. So that's the reason I acknowledge it's tight. And Monique did say to me, this is tight, Tim. I said, is it doable? And she said, well, probably, but it's tight. I think from her perspective, she'd like a bit longer. But I've done this for a reason. But you know, over to you guys. If you want to change that, I'll run with it. It's not impossible, but it might become a bit untidy.
Fair enough. I mean, I can accept that your reasoning there, and it's definitely tidier if it fits in within a financial year kind of period. I'm not sure that the beginning of next financial year is the right financial year. So in that case, is it? Would anybody support me in changing it to the 1st of March 2026?
The financial ramifications are getting higher for our ratepayers generally.
I know, but there are lots of other ramifications as well.
Well, you can put it on the table if you want to see.
Well,
Yeah.
Put it on the table and see how councillors feel.
Jonas.
That will require a second. So you were moving and seconded by Councillor Munt. Okay, we now open that up for discussion, councillors. Councillor Hess.
Oh,
sorry.
Oh.
Councillor Dean, I'm
I
sorry.
believe mine was on from the previous one.
Yeah.
I would like to speak on this, but I want to think about it from our first.
Okay.
Councillor Hess.
I'm going to vote against that amendment. I realise that we have a certain amount of occupancy over the Christmas New Year period. It's always been a good time when you've got full occupancy of those that come to use the facility, that they've been available for the consultation process. And for that reason, I'm going to vote against the amendment because that enables more people to be involved in the consultation process over that Christmas, New Year period.
Thank you, councillor Hassan. Councillor Miller.
In the same vein, I vote against, but for a slightly different reason. I think it's a good idea to put some tension in the system to keep us all engaged and keep us actually progressing it. What I would suggest is that if it's patently obvious that it's not going to work, that I would personally be open to you coming back to me and saying, actually, this is not working. I need another month or two. Now, I think that's probably a more appropriate way to do it, is let's put an end date to it. But if it's not working and it becomes clear, let's be flexible enough to say, no, it's not.
Thank you, councillor Miller. That's a very sensible suggestion. Councillor Munt.
Yes, I do feel that Grant's suggestion was sensible. However, I think Sophie's suggestion for the amendment is more robust. The reason being because we are facing what is considered the highest level in our significance and engagement policy. Therefore, timing this to our timeframes rather than to receive a best outcome for our wider communities, we need to consider the risk that that brings. And I think we need to be very, very aware that this is people's livelihoods and homes that we are making big decisions about. This is not a small matter.
Thank you, councillor Munt. Well, I'll put the amendment.
May I reply?
I'll reply, yes.
Phil was going to say something as well.
Yep.
Did you
on this as well? Yep.
Representative.
So I support councillor Miller's proposal. He says put tension in it, and the reason why I support it, and I do think that you can do proper engagement. We do it before on other significant matters like long-term plan in that time frame. But if we actually put it forward to March 2026, remember that that's pushing it out to another council to go through this again.
Very good point. Right of reply.
So I guess in terms of it being another council, that I can see your point, but it's already gone through several different councils. And I guess in some ways that's been an issue, but at the same time, that doesn't necessarily mean that we have to do things too quickly. In terms of putting some tension into the process, I'm fairly certain we've already got quite a lot of tension in the room. And in terms of the amount of time to go through what is a very complex situation environmentally and socially is, I feel that this is, obviously I feel that this is a too short a time frame. And in terms of occupancy over the summer, honestly, I think you've almost helped my argument because that would put 2 summers in there. Yeah. So you'd be able to, yes, it involves back and forth a wee bit, but at the same time, there is still something that's going to have an implication of at least 15 years and probably longer. Making a decision over it in a matter of months it just feels wrong to me. So that's why I'm moving this.
Thank you, Sophie. I do agree with Councillor Miller. This has been a long process, and that's why we've got to where we are today. And I do think that moving on with engagement and consultation as soon as possible is important. But however, I will put the motion. Those in favour of the amendment to the date, say aye. 2. Those against? I declare the amendment lost. We will now move. Representative Mackay, you wanted to make some comment.
You're still on, no?
Yes, I was, but it's okay.
Okay. Well, look, I just wanted to take the opportunity to talk to Taumatu's engagement on this kaupapa so far. And I thought I'd just start from the same place I started from when I spoke to this in March, which is to acknowledge Kirili Fee for your comments today, it is really hard to turn up and represent a community, and you did that well. So, so kia ora. What I thought I'd explain, and I'll speak quickly, is who is Taumotu, what is my role here, and what are the decisions around Green Park that I'm aware of, and engagement with our Runanga. And I'm sharing this information because I can see this will be really helpful for the community and council to have that better understanding. And so Taumotu Runanga, we became a legal entity in 1991. We chose to become an incorporated society, and we have over 30,000 registered members. We have an executive committee, which is made up like any other incorporated society of a treasurer and a secretary and a chair. There are 10 members of that executive committee, and I am not one of them, but I am appointed by the executive committee to be here in this role. We have public meetings 6 times per year where any of our 30,000 people can turn up and participate. In terms, we are not Te Runanga and Aitahu, so we are one of the 18 members of Te Runanga and Aitahu, but we're a small coastal based community. Te Runanga and Aitahu is a legal entity with billions of dollars. So my role here is to be a representative for my community, and I do not have a vote around the table. And for that reason, back in March, I asked for special permission to read a statement on behalf of Taumotu, which is normally not allowed or not permitted in a public forum. It's a questions-based forum. And that statement was not a personal statement by either myself or the chair, Liz Brown. This was a statement that I was directed to share. And actually that's the only extent of my mandate, is to actually share statements on behalf of the community, or my community. In terms of Green Park, Taumotu does not own Green Park. Te Runanga and Aitahu owns Green Park, and they're the decision maker. On the 14th of July, so 2 Sundays ago, we had a Runanga hui where whānau turned up and they put forward a resolution to Te Runanga asking for Taumotu to ask Te Runanga o Aitahu to reconsider the decision in regards to one person at Green Park Huts. And at that meeting, our members sought an amendment to that. So it was not just one person, but actually all people who have Ngāi Tahu whakapapa. And that motion was passed, and it's a reconsider only. So the decision, as far as I know, still stands. And my understanding of that decision is that when I spoke in March, it was that the huts were to the leases were to come to an end on the 30th of June this year. And my understanding is that's been extended to maybe 6 to 12 months, but I'm not quite sure of whether it's 6 or 12. But Taumotu does not have a decision-making role in that. That's Te Runanga and Aitahu. In terms of engagement with our Runanga, we are a primarily volunteer-run entity. We have a really small staff team, and the way to best engage with us is via email, because our small staff team are part-time. And the only comment that I would say about that is, for us as a volunteer entity, we often choose to move into formal processes and informal processes to express what we view as those things that are most important to us, like kaitiakitanga, environmental outcomes, and rangatiratanga. So having our history and our footprint across our takiwa, our traditional areas. And, you know, that could be any type of consultation, from a resource consent through to the long-term plan. And what's slightly different about the expectations on my mana whenua community is, if we have a position that does not agree with somebody else's position, then that someone else always expects us to engage with them directly. No other community has that level of expectation upon them. And what type of result or toll does this sometimes take when you stand up? And you'll know this, Kitterly, from when you stand up and you speak. And I will share this, even though it's public. But both Liz, myself, and one other member of our runanga were approached by the police to have our houses put on a register. Not because we knew the threat against us, but because they knew the threat against us. That's what comes with the responsibility of leadership. And I don't know what the threat is, but I will just say, I do speak for my community and I'm proud to speak for my community. And sometimes that might not actually align with other people's views. So kia ora.
You know what I mean? Thank you for that very sobering comment. Councillor Dean.
Well, I don't know how to follow that. I'm going to follow with process. I look, as the second of the motion, I guess I am coming in with caution, Tim. When we use words like environmental triggers, let's make sure we know what they mean. Let's make sure they're defined. If that's the path we're going to go down, let's make sure that we know what we're negotiating on, that we're happy to negotiate on it. Remember, we're not negotiating for just this table versus the Upper Selwyn Huts. It's the rest of the Selwyn district is negotiating with the Selwyn Huts. Things like district-wide rate, there is a ramification of that for the entire district. So our process needs to be, we need to have a really understood process between council and the Upper Selwyn Huts committee. But with the knowledge that, in fact, the whole Selwyn district is involved in this process. And indeed, when we go to, it may well be something that needs to involve some sort of a consultation across the entire area. So I'm confident in sitting, and I think it's wonderful that it's been pulled together. And I thank everyone here in the public gallery who's helped us come to this point, lawyers and all. And I just, as we go forward, let's make sure that we hit those stepping stones on the way.
Thank you, Councillor Dean. So Harris, you want
Thanks, Phil. Yes, the council will be the ultimate decision maker, and the consultation process will be open to the whole district or anyone.
Okay.
Like the long-term plan was, same process.
Councillor Hassan, I'm mindful that the day is drawing on and we've all had a crack at this.
Okay, I just want to ask one clarification. And it's to do with 4.7 in the body of the report. And I guess it actually concerns the deed of license with regards to E. So we're pausing the deed of license being issued from a period of 5 years with the conditional renewal of the deed of license for the other periods of years. In 4.7, you explained through us the costs of the actual license fee that is currently on the deed of license at $1,389. And I'm just wondering, with regards to how that figure is arrived at with regards to the income license fee, what is up for negotiation when you are actually consulting upfront with this community about true costs? When we're talking true costs of the license fee, we're talking true costs if we take them under the sewage and the water. So it's coming back to, are we looking at market costs, or are we looking at just continuation of historic costs? Because these are important matters. Time doesn't stand still with regards to, fees and licenses and funding.
I can say that, in my view, the matters that you speak of would be under discussion through the engagement and consultation process. I think the license fee probably isn't at market rate. Maybe it should be. So these things could be discussed. Whether they're on the district-wide rate is another point of discussion. If not on the district-wide rate, how much do they pay over what period of time? So all the financials is certainly one of the key components of the discussion.
Right, thank you for that point of clarification. We now have a substantive motion here, which has the alteration in G to engage and determine. And I'm going to put that motion. All those in favour, please say aye. Aye. Against? Carried. And in having that carried, thank you, Mr. Harris, for the work you've done and everybody involved. And I look forward to you all working together to give us a solution to the future for the Upper Selwyn Huts. Congratulations. We have a lot of work to do. So we are now going to move on to item 7. The representation review. Yeah, poor buggeries. Right. Are you ready to carry on, Mr. Harris, or do you need a 2-minute break?
No, I'm good.
You're good. Okay. Let's move on to the representation review. We've had a public forum today on this question, and we will now get on to the substantial business on tab 7.
Thank you, Mr. Chair. And again, I'll walk the council through the report and take questions at the end. So we start off with a set of recommendations, but the council will come back to those at the end. The purpose of this report is to present to the council the recommendation of the Representation Review Subcommittee for the initial proposal for representation arrangements for the 2025 and subsequent local elections. Significant statement. It is a highly significant decision. Local elections are a significant impact to the entire district, and that's why it invokes a full consultation process. At number 3, I talk about the background, and there's a few points I want to make here. So councils are required to go through a review, this type of review, every 6 years. This council took their last review back in 2021, which is only 3 years ago. There's some reasons for that. It's mainly around the growth of the district and the uneven growth of the district that has meant that the wards don't quite make sense in terms of the statutory framework as they did 3 years ago. The process, and this is quite a legislatively driven process, is set out in the Local Electoral Act 2021. There's some key concepts that the council need to be aware of. Some of the factors that the council needs to include are communities of interest, effective representation of communities of interest, number of elected members, fair representation of electors. So there's some key, quite conceptual ideas that we had to get our head around in terms of the subcommittee's work. One of the driving statutory requirements is the plus minus 10% rule. So it is sometimes difficult to get your head around this rule, so I'll read this out. So there's a statutory requirement of fair representation is that the proportion of each ward divided by the number of members to be elected by the ward must produce a figure no more than 10% greater or smaller than the population of the district divided by the total number of elected members. And those numbers are quite clearly set out in the table within the recommendations. So that's one of the factors that meant that it was appropriate to do a review 3 years afterwards, because we clearly weren't meeting the plus minus 10% rule because of the growth mainly in Rolleston. So yes, Selwyn's population has grown rapidly in recent years, but this growth hasn't been even across the district, and this means that the existing ward boundaries are no longer appropriate. So with the significant changes in population, work has been completed to better understand which representation scenarios best provides for fair representation of electors, and I'll come back to that a wee bit later in the report. We did a lot of work, a lot of analysis that was undertaken to ensure a sound understanding of the views of the residents of Selwyn, and the preliminary work included discussions with 3 other councils, a lot of subcommittee workshops to review different scenarios, qualitative and quantitative research commissioned to canvass residents' views, communities' interest and fair and effective representation. And then we did some preliminary consultation around a couple of those options. So we went through a few range of options from no wards, so the people who are elected at large, through to 2, 3 and 4 wards, and with the number of councillors ranging from 7 to 11. Another key component of the process is to consider its options around community boards. And currently the council has only one community board, which is the current Melbourne Community Board. So the use of community boards has traditionally been a way of ensuring local views are heard. This meant that community boards were broken into subdivisions so that the elected representatives could easily service the needs of the subdivision. There's been significant changes over the last number of years, partly brought around by COVID and changing technology channels. When I say that, I do acknowledge that certain parts of the district haven't got great connectivity, but I think there's a trend in terms of how people connect with their communities and their political representatives. And our pre-engagement and our work indicated that the meaning of local has become rather indistinct. And this has been further borne out in the latest pre-consultation, with a significant increase in participation was achieved using different technology. And we saw this again in the long-term plan. This was a pattern that we were very successful engaging people through multiple channels, and the old town hall meeting is losing, I guess, its original impact. So the pre-engagement research that we completed towards the end of last year, September, I think, undertaken by a company called Research First, who is a very reputable marketing consultancy, indicated that residents were tending to lean more towards their councillors and the council rather than their community boards or the community board. So there were some questions asked. One is, who is primarily responsible for representing residents' interests and opinions? Only 7% answered the community board, with 33% answering the councillor. And again, that figure was 9% of the Melbourne residents, where there is an existing community board, who consider the community board as having a primary responsibility for representing their issues and options. So our pre-engagement research indicated there wasn't a strong desire for a community board. Now, notwithstanding that, I do acknowledge that there is a strong, or a degree of local support within the Melbourne area, and this was evident through the efforts of the Darfield Association and Melbourne Community Board when it collected a number of responses through our preliminary consultation. The view of the subcommittee is that should be tested and discussed and considered through this fuller consultation process, and that's where we're at. At its 15 March 24 meeting, the subcommittee considered the option of not including community boards with two options for pre-consultation. So at number 4 in my report, there are two options were put forward by the subcommittee for the preliminary consultation. The first was the 4 ward with 8 councillors, no community board option. The second was the 3 wards and 9 councillors with no community board. I want to make it clear also that this preliminary consultation is not mandatory. It is understood to be best practice, but a number of councils across the country do not actually go there, and they go straight to a full consultation process. But we try to follow best practice, and we put out some discussion, hoping to capture some views and discussion from the 2 options that we put forward. So the preliminary consultation was open from Tuesday, the 2nd of April and closed on Thursday, the 2nd of May, 2024. There was a number of channels that we used, online engagement, printed information, a workshop with the Melbourne Community Board. We used media releases, council call articles, social media, information, council website, and engagement HQ. As I said before, drop-in sessions were not used as the last representation review turnouts were actually quite low using that method. So at number 5, I discuss some submissions and findings. Firstly, noting that the 2021 review process only attracted a total of 106 submissions. This process more than doubled that, with 229 submissions being received. I want also to acknowledge that in addition to the official council channels, the Darfield residents and Melbourne Community Board received 219 responses. So table 1 just sets out that level of response. I guess there's 2 key principles to be aware of with the representation review, and these being effective representation and fair representation. Effective representation relates to the number of wards and their locations, whereas fair representation relates to the allocation of members to those wards. So the 2 key concepts. One of the constraining factors in terms of achieving effective representation was the plus minus 10% rule, because of the concentration of population around Rolleston and the relative scarceness of population in the rural districts. It was quite hard to get a figuration that met those numbers. So the 4-ward 8 councillor option takes the approach that the existing 4 wards are quite well recognised. They contain relatively strong communities of interest. And indeed, I think the pre-engagement did find strong communities of interest, particularly in Melbourne and around Rolleston, probably less so around some areas in the Springs ward. Our research showed us that there continues to be strong desire for the principally rural sectors of Sauron District to continue to be subdivided in 2 wards. The pre-consultation further supports the findings of the research done in September of 23, that 4 wards most likely align with the community's concept of local and effective representation. So the subcommittee came to a view that the 4-ward option also proposed less councillors as being more appropriate for effective decision making. And also the issue of the funding pool that was discussed earlier on was that more money in the pot would bring in more potential candidates to the council table. Excuse me. The 3-ward option took a different approach. It identified or merged Melbourne and Ellesmere areas together on the basis they had similar interests. However, it became pretty clear through our pre-engagement, pre-consultation, that this was not a favoured option by the people in Ellesmere or Melbourne, and that Melbourne should retain a strong community interest that was unified and supported by at least 1 councillor. My screen has decided not to play here. Sorry. So if, Mr. Chair, you'll have to excuse me while I reboot my computer. I've got notes in mine, which is rather annoying. I don't know why it's gone to that. Where are we? Yeah, so the three ward option combined the two, the Melbourne and the Ellesmere communities, but again, as I said before, there was a clear feedback that this wasn't a preferred option. So if I go to 7 in terms of consultation and next steps, we're considering the recommendation today in the 24th meeting. It's a statutory requirement that the initial proposal must be publicly notified no later than the 8th of August 2024. And then we'll go through a notification process and a submission process that'll stretch through August into September. The actual, what that'll look like will be very similar to the long-term plan process with a number of different channels for engagement. And we'll use a lot of media releases, social media activity, council website content and target electronic mail to advertise and to get good coverage and good input into our process. Again, like the long-term plan, we'll go through a full hearing process. And at the end of my report, I include a timeline and happy to take questions.
Thank you, Mr. Harris. We have questions from Elizabeth Munt.
Tim, I'm just going to fire away. So you might want to take notes. I've got 1, 2, 3, 4, 5, 6, about 6 or so things to discuss very quickly. Will the names be written as we see stated here, or will they be recorded with just the Māori names for the wards? Can you just give some clarification around what that actually looks like when it's written down? And the financial benefit.
Let's deal with one question at a time, please.
Okay.
The first one.
Thank you, Elizabeth. And I was probably a bit remiss. The Māori names, I didn't mention those too much in the report. And the reason for that is that we got them in a fairly late time frame. And thank you for Taumuti for supplying those names. So they're bilingual names. So they're going to be, they're dual names. So they're going to have the Māori component and the English component. They can be used alternatively or together. And so those Māori names, I guess, align with some key geographic features in the district. The Springs area, the plains, Te Waihora, and the hills and mountains of the Melbourne area. So I think they're really cool names, and yeah, I think it's a good move.
Continue, Elizabeth.
Right. So obviously there's a financial benefit for future elected members. I see that as, that's one of the options there. Does the Electoral Commission pay currently for the elected members' salaries, or do the ratepayers pay?
It's a pot of money that perhaps my CEO could help me there. So it's a pot of money set by the Remuneration Authority.
They pay.
I don't
just
too
set
sure.
what we pay.
I think it comes out of the ratepayers funds.
Ratepayers,
But they set the size of the pot.
Yeah. So I guess a part of what I've read in this document is it's very difficult here for the understanding of the concept for elected members getting along to community events, turning up for individual issues. It's really hard to quantify the amount of sort of drive time, like Lydia and I, for example, in our very sparse rural wards, and quantify actually how much effort that encompasses. And it would be good if that was a key consideration in the report, if there's any way of retrospectively adding that in. In terms of the engagement timeframe, obviously we've just had it where it's clashed with the LTP, and that was difficult for the community because they were so engrossed in the LTP. Will this upcoming consultation period, can we ensure that that won't clash with anything else, and to give people a bit of a breathing space? In terms of the rural representation.
Do you want to answer that one, Tim?
Yeah, we have a consultation calendar. I think it does
Okay,
future sale and might overlap to a degree. It's very difficult, if not impossible, to get a particular process that needs consultation not to overlap with some other ones. So we do our best.
And we have a statutory time frame.
We do. It has to be at least a month. We've got a week extra, I think, just to help that engagement.
Okay. Is there any other way that we can look at going back to the government or to whoever issues this, because I'm concerned about the rural representation with the changes, because obviously this is based solely on population rather than a distance travelled, and also including how many community groups committees, etc., that we have to attend. So it would be nice to know that there was another avenue that can be explored here, and if you could please advise.
I'll answer that now, so I don't forget, Elizabeth, that's all right. There is the ability to apply for exceptions to the 10 plus minus % rule, which drives some of these outcomes. However, we were advised, and it's to the Local Government Commission, we were advised that the bar threshold for that is very high and we're unlikely to succeed. We've reached a time frame now that wouldn't be possible to make that application, so that even avenue for this process is closed.
Right. And there's obviously the talk about, you've mentioned more money brings more people to the party for people running for local government. But does that fit with our needs and values? Because we've talked about diversity, and from what we've seen in the past, when you bring in more money, there is the risk, is there not? I'm putting this to you as a question. Is there a risk that we'll get people coming in for personal reasons rather than to serve their community because it's an employment option? Is that being considered?
Well, this is just my personal view. I don't think that the pot's going to increase a lot, that this would be an attractive proposition for a lot of people. So I don't think going to come people thinking they're going to make their millions out of being a councillor around the table. But it certainly means that maybe more people that represent different parts of our society might be able to see it as an affordable option that they can do. That the increase, just in rough terms, moving from 10 to 8 is 20%. So that would be ballpark. How it's distributed is yet to be determined.
Also, when we put this new proposal out for consultation, will it just have the one option? People are consulting on the one option, and will there be an option here where people can say we'd actually prefer the status quo, or an option where they can put other and they can put their own considerations in?
Yeah, we're here today to decide what option we want to go out with, and there's a recommendation there for the 4 ward 8 councillor option. So that's the one we'll be going out for consultation on. But the submissions could suggest a whole lot of things. So they could suggest status quo or do something different.
Thank you, Councillor Munt. Councillor Hassan.
I want to move an amendment, and it's based on.
Order, we don't have a motion yet.
Oh, sorry. Well, I'll leave my amendment on the table until we have a motion then.
Well, let's wait till we've got a motion. So any more questions on the report? We have
Just.
Councillor D.
Yes, look, I wanted to talk about a couple of things. Obviously, as the chair of representation review, I just wanted to briefly talk about it, and I wanted to move the motion at the same time. So I can move the motion and speak in support of it at the end if that's the most appropriate way. I'll move the motion as it stands there.
We have a mover for the motion. We have a seconder.
Yes.
Councillor Hedingham. Second, Councillor Hedingham.
I'm moving an amendment.
Okay, Councillor Hassan is moving an amendment.
Okay. I would like to introduce the question with regards to the consultation process. Should community boards be established for each of the 4 wards as a question? And the reason why I want that as a question is because of our population growth and the fact that we have basically disestablished our community committees, which in the past acted many cases as a conduit for actually fulfilling the process of a community board, especially in the Springs and the Ellesmere area, which did not have community boards at the time when we used to have the Rolleston Community Board. And it was a very effectual process. They were classed as subcommittees of council.
Do you have a wording of your amendment?
Yes, I have. It's the question is that community boards be established for each of the 4 wards. And I was just speaking for the reason why.
Thank you.
Our growth, disestablishment of community committees. The public should be able to have a say on that.
Do we have a seconder for that amendment?
Yeah, all right.
Yeah.
A long day. Councillor McInnes. Tim?
I just seek clarification. I must have misheard. I thought you wanted that as part of the consultation
Yeah.
process
Yes, yep.
rather than a resolution.
Well, no, it's part of the consultation process,
Yeah.
asking the community whether
Yeah.
they want community boards to be established in each of the 4 wards.
You know, that's fine. The way it was written up there, it looked
Oh,
like we were going to vote about having 4 community boards.
No,
Which would undo the work of the sub.
it's because it's got to go out to consultation. I think that should be part of the consultation process.
There's a lot of names on here of people who I'd like to speak to that.
Well, we can all speak to that amendment. So councillor Epi Ha, are you speaking to the amendment?
Yes, the reason I don't support it is because that conversation has been had already through robust consultation and committee discussion. Some of it I've participated in, some of it I've watched online. Ellesmere have made their, from what I know and the work that's been done, have made their position quite clear that they don't support a community board. I'm concerned that by putting it in now undoes potentially some of the work that's been done, but I'm interested to hear from other councillors.
Thank you, councillor Epi Ha. Councillor McInnes, as a seconder, you have something to say?
Actually, the reason I put my light on is because of V right at the bottom in the middle of the screen there. It talks about gifted te reo names for community boards.
Yeah.
When I believe it should say wards there. So it's not so much an amendment as a correction.
Thank you very much for that eagle-eyed correction. It's good to see with this long day that people are still sharp. Right, councillor Glidden.
I would like clarity on what we're talking about right now. Are we talking about including a question in a consultation document? Does that need to be a resolution up on there, or are we just supporting that that is included?
Technically doesn't need to be a resolution if you're just supporting that it's included in the questions.
Great, I support that it's included in there. I've one question. And I asked this in the representation review and I'm still not clear on what it is now. The names, and I'm really appreciative of the names that we've been given. It's just that Tawera is currently a subdivision.
We're not talking about that at the moment.
It's a question.
Take the, overthrow.
It's just on clarity of that because it's a subdivision within the Melbourne ward. So Tawera is a subdivision within the Melbourne ward, and yet our proposal is to call the ward Tawera Melbourne. So I'm not sure how we work through that, and that is probably something that might come out in the consultation.
Yeah, the way if I may, Mr. Chair, the way I see it is that through the decision-making process, if there is a view to keeping the Melbourne Community Board, we would need to change the name of one or the other. But that could be part of a decision process.
Yeah.
Very well. And I would like to speak against the motion that Phil has put.
Okay.
We're not there yet.
We're not there yet. Right.
I'd like to speak against the amendment, if I can.
The
amendment, that's what we're still talking about.
The amendment.
They said it's not an amendment.
It's an addition to the.
They said it's not an amendment.
It's an addition to the
Waste of time having.
consultation paper. But I will speak, please, councillor Dean.
Well, there's an amendment with a seconder, so I assume that we are still talking to the amendment. I know it's a long day. I'm going to speak against it because it's something that we went out to for pre-consultation and we went out for early consultation. And when the information came back, it came back saying that people didn't want community boards. So we've already got that consultation back. We've actually had it back twice now already. And in both cases, we doubled down by saying, who do you support? And they said, we support our councillors. Their question went out saying, when you want to engage with council, who do you go to? They said we go to council. 70% of our population said that they go to their council, to their community boards over their councillors. 9% of Melbourne, where there was a community board, only 9% said that they went to the community board. The rest said that they went to the council. So look, and that's why I'm speaking against it, not because I think it's the wrong thing.
Integrity.
Thank you, councillor Dean. Now, what you've proposed, councillor, is a addition to the paper. Is that correct?
What I've proposed is that where we have that the Melbourne Community Board be disestablished, right? In the recommendation itself, it should have should community boards be established for each of the 4 wards? And that's
It's a direct negative.
No, it's not.
It's a negative to should the Melbourne board be disestablished.
Well, change E to F.
No, I'm sorry, I'm.
Okay. Well,
I'm-
it still stands that I've put forward that should be in the recommendation, so.
Well, let's deal with that issue.
So, sorry, can I just clarify, because I know I seconded it, but I'm just want to check. So instead, rather than what you just said there, are you asking that in the consultation document, it says, instead of that 4 community boards be established, how about that the consultation asks the question of whether residents would like 4 community boards to be established at a future date? Because you're not necessarily talking about right now. Or do we just, I'm not quite sure where we're at.
I think you're in danger here of undoing the work that the subcommittee has put together and putting this together.
Because I think this
You're
is-
going to withdraw.
Yeah.
I think that's very wise to withdraw. So your suggestion has lapsed for a second. Right, so let's carry on with the debate itself. And I have councillor Epiha with his light on.
Thank you very much. Just further elaborate on my seconding of the report, the recommendations. Just want to thank both of the community board members today for your presentation, your submission. From what I understand, the work has been done through the committee, and I wanted to thank the members of that committee and also the Rangatahi members that put a lot of work into it, and also the Mayor Sam as well. From what I understand, it's population-based, not geographic or distance-based. The opportunity, or I guess the move into the future, given our expansive growth and population growth, is qualitative over quantitative, and I explain that by what we see here is an opportunity to increase remuneration, and we've just discussed where that comes from, and it's set by the External Remuneration Authority. And what I'm seeing, or what as a councillor, the amount of inquiries and committee meetings have reduced due to the quality of engagement the community that I represent has with council. The council through our CEO. So the number of inquiries generally to me as a councillor were of an operational nature. And I think by going out to consultation, not only will we potentially see, not a high quality, but other representatives potentially step forward, we'll also transition into a space where geographically we're more connected through our digital space. And we saw that over our long-term plan with an unprecedented amount of engagement. I wanted to thank Te Taumutu, or our Ahuria here, for the gifting of the names. Is in line with our Te Rautaki Tikakarua bilingual strategy that this council adopted. I think the names are beautiful as they sit here as the wards and show a clear reflection of partnership. Considering that we're sitting in the statutory timeframes, the work has been done by the committee. I thank you and commend the report. Thank you.
Kia ora for your comments. Councillor Glidden.
I do not agree with the recommendation to take this option to consultation. I don't believe that we have this right. I guess delving into it, the main reason for less councillors is effective decision making and increased remuneration. And I start to think of the challenges with one councillor being equitable in making those effective decisions for 14 communities in the Melbourne ward. The Local Government Commission does not use remuneration as a deciding factor, and this factor should be excluded from reasoning. This role is an act of public service, and no one should be in this role for money. And if you are, you're here for the wrong reason. It is well known and received that fair and effective representation is the four-ward system, with 65% of respondents preferring this option in the preliminary consultation, particularly our rural wards. However, having one councillor to service 5,000 square kilometres leads one to think that a ward may not have that fair, oh God, it's died, equitable representation as alluded to in the feedback from the preliminary consultation. By decreasing to one councillor, it makes this an unappealing role. The demand on the rural ward would create an unbalanced workload, and this unbalanced workload would increase substantially with the loss of a councillor and 5 community board members for the Melbourne ward as proposed, making equitable representation a challenge. I take in the consideration of access, distance, intermittent lack of technology, and 14 communities for one councillor to represent the Melbourne ward. The Melbourne ward sees that it has been let down and will not be represented fairly. If we consider the Melbourne ward growth predictions and the unique geography of alpine, rural, and semi-urban environments within that 5,000 square kilometres, and take into account the information gathered from the preliminary consultation, I believe there are other options that would mitigate the concerns of this representation review that did not consider these options. I have concerns that if we could not consider change at the representation review, how will change be considered at this table? And to give you an idea, Elizabeth, between Bob and I, we travel 20,000 kilometres a year. So we'll be voting against.
Thank you, councillor Glidden. Councillor Mudford.
I don't really think I have much more to say after that. But the one thing is, I keep thinking of, at the moment, we've got 7 representatives in our area at the moment. We go down to 1. I hope that's no reflection on how many we needed before. It's, yeah, I think it's a bit of an insult, to be quite honest, that people think that one person could look after Melbourne. So if that's the way it's going to be in the future, I think it's going to have to be a council that is actually going to have to be split, and people will be helping one another, and it'll be a Selwyn council, not an area council, because I can't see it surviving like it is.
Thank you for making those points, councillor Mugford. Councillor Dean.
Mine's a deputy. I'll speak last, if that's all right. I'll speak to finish off the support the.
Although there's no other, Elizabeth, you're wanting to speak again?
Yeah, no, I'm just wanting to, I agree entirely with what Lydia have said. And I am concerned for the rural voice within this council going forward, because this is in effect, future representation reviews will continue down this path, because we know that the growth patterns are predominantly in our urban environments, and our rural population needs more representation and more personal representation than potentially the urban digitalisation that we seem to be hearing about.
Well, I'd just like to remind you, this is a proposal going out for public consultation, and I'd hope to think that people have a closed mind and not an open one when we come back with the information from the consultation. Councillor Dean.
Well, thank you. Look, I just wanted to remind the council that for the last almost 2 years, we've been considering these options at the request of this council. I'll reflect that the makeup of the group that we had that was making these decisions was representatives from each of the wards, plus a representative from the from our one community board that we had, as we wanted their voice at the table. Plus, also we had representatives from our youth council. We had some robust conversations around this. We were supported through this process by Tim and by Murray, thank you, Murray State, who's been through these several times before, and it's Murray spoke to us about the plus or minus 10% versus the geographical decisions that can be made. He drew parallels to our ward, and we debated that at length around this very table about around that. Couple of numbers I want you to just consider before we, in support of why I've moved this. We are approximately 10,000 ratepayers per councillor, around about. Now the ratepayers pay us for that representation. Yeah. If at the present point in time, if you live in Ellesmere or Rolleston or Springs, you have 1 in 10,000 around about. If you live in Melbourne, you've got 1 in 1,500 because they have 7 representatives in that area. So the representation review is responsible for reviewing the representation of our ratepayers. The rules have been given to us by the government, which says you will look at the number of ratepayers you have and you look at how you represent them. So if you live in Rolleston or Ellesmere or Springs, you should be saying, why would, if I move to Melbourne, I will have more representation in Melbourne. Yes, they are burdened with geography. I absolutely accept that. And that is the way that this council will have to run. As Bob said, we'll have to look at saying the way the council runs won't be the way that we're running. We're going to have to look at things maybe on issue by issue as opposed to our solid geographical area. So we take the Melbourne Community Board out, for example. Then we go and say we do add another person into both Melbourne and to the Ellesmere area. Now, if you live in Melbourne or Ellesmere, we're now 1 in 5,000. We're now 5,000 people, and we're well over our plus or minus 10%, well outside the one at plus or minus 10%. But now now if you live in those 2 areas, your representation is greater. So that's the reason why the kind of philosophy behind everything that we were doing on the representation review was to review the representation in our growing community. Yes, it is likely we're going to have to do it again soon because we know we're the fastest growing district within New Zealand, and we're going to grow fast. I'm getting to my point. I will stop talking. So I'm supporting it as it stands there. We should go out to consultation as it is. When the consultation comes back, we should openly look at it again and see what our community says. And then if we're going to go and challenge the Electoral Commission, that's when we do it in that way. So thank you. I will finish there.
Thank you for that summation. I'd just like to say that in my 30 years in local government, I have seen the demise of 2 community boards. I've tried to resurrect the Springs Community Board back in I can't remember when it was, but it'd been 95 after it died in the first term. I'd be very interested to see what the public come back to us with, and we must keep an open mind as to what the public come back to us with. So with those comments, I will put the resolution. All those in favour, please say aye.
Aye.
Against? I declare, show of hands, please. All those in favour? 1, 2, 3, 4, 5, 6. Those against? 1, 2, 3, 4, 5. I declare it carried. So thank you for your input, and we will move on to the next item. Well, we'll have a 5-minute break for a toilet stop.
Well, Your Worship, before you do that, could I suggest, in the interest of moving along, that I move that the tab 8 and tab 9, that the mechanical reports be taken as read and we move on.
I'm happy to move that. Happy to second those.
Yes, thank you for that. All those in favour say aye. Carried. We will just have a 5-minute break for a toilet stop, and we'll be back in here again. All right.
You know what to do?
No.
You don't want to talk to me?
What do you want to say? Not determine whether I want to talk to you or not.
We come back and we
thank you, You can stand if you wish. You'll get tall that way. Excuse me, Bruce. Councillors, the next item on the agenda is the Central Plains Water Trust Statement of Intent. And I believe there's been an omission in the report that Ellie Archer should be put in there as a trustee. After that, it's correct. So is there any questions over the report? Okay, moved by Councillor Dean, seconded by Councillor Epiha.
Yeah.
All those in favour will say aye.
I just have one question.
Oh, yeah.
Around the increase of funding and what it relates to. All I can find is that on page 80 or 87 of diligent, there's an increase, but I just wanted to ask what in relation to, is it inflationary or?
The increase in funding is what Central Plains Limited had budgeted, so an inflationary increase, and the trust must work within that budget. So they have actually set themselves an increase in remuneration within that budget.
Okay, thank you for that. Happy to second.
Thank you for that point of clarification. There'll be no more comment. I will move that resolution. All those in favour say aye. Carried. Thank you. Yeah, I note that Councillor Miller stepped back from the table for that that piece of that item 10. Right, item 11, partially operative Selwyn District Plan mediation outcomes.
Can I just ask a question? So with the hearing commissioners who are on the district plan, we are okay to sit at the table for this? Just wanted that clarified.
Question is, we
question.
commissioners are able to sit at the table for this. I believe we are, because our part of the process is finished.
Yeah, essentially this is just an update to make sure that you're aware of how we are tracking on those appeals. So there's a summary in the report there. I'm happy just to leave that as read and answer any questions on that.
In your deputy worship, can we take this as read because it's just an update?
Yes, this is what we're looking to do. Councillor Miller, it's been moved moved by Councillor Mugman, seconded by Councillor Munt. All those in favour of tab 10 say aye. Tab 11 rather say aye. Thank you. Moved, carried. Thank you. Thank you, Ben, for your efforts. It was good reading. Item 12, artificial intelligence. We need a bit of that today. The floor is yours.
Thank you very much. So this is a paper, just to let the council know that we've put our very first artificial intelligence policy in place. And we're recommending that the council receives this policy and endorses this policy.
Moved by Councillor Epiha. Councillor Dean, are you seconding it?
I am, but I have a question.
Seconded by Councillor Dean, and
Happy
question
to,
for Councillor Dean.
happy to take questions, yeah.
My question is that the nature of this and the AI moving as fast as it is, can it be elevated up on the review process so that it's so we review it a bit more regularly than we would a normal policy document? Because I think it's as AI is changing so rapidly, we may want to change our policy more sooner than what a normal review might.
Yes, and that is the intention. So we've put this in place to mitigate the risk of basically ChatGPT that came out nearly 2 years ago.
Yeah.
It's a point in time to mitigate that risk. We're about to implement that type of technology into our next Microsoft product, which is called Copilot. That will be coming end of this year, halfway through next year. It will then get another update, right? And then moving from that, we'll then have another major update. So yes, it will be regularly updated as we implement new technology.
It's good to know because as all industries all over the world, AI is going to be dominating our industries, whatever industry you're in. So
yeah,
thank you.
Thank you.
Thank you, Councillor Munt.
Yep, just on that same note with risks and the obviously legal information management, is there a statement that you're going to put out to the public to assure our constituents that there's not going to be any breaches and that we've got on the ground policies in place so that the staff are well aware and don't subject any of our information to a data breach?
We haven't yet, but we can, yes,
Okay.
out to public.
Thank you, councillor Hassan.
Mine's briefly following councillor Munt. Just conscious that this could be an internal policy. And I see that it wasn't attached to our policy manual. I have a strong, I support strongly that where we have internal policies, that we do manage to highlight in the policy manual that we actually have a policy in place for our public to ask questions if they wish to, or know that we have that policy in place internally. So that's where I'd like to see it actually end up. Not the whole policy, but just a reference to it.
I think we can cover off by the fact that what's likely to go out with this is a media release that talks about the fact that we have an artificial intelligence policy. And part of our update, and particularly around our website, is about the ability to have policies that may be internal but of interest to the community, available and easy for viewing. And currently we don't have that, but that's what we're aspiring to in the future, so that people can find internal policies of interest to them.
If they're attached to the policy manual, it's a one-stop shop.
We are going to overhaul the whole policy system. It's a multi-year project.
You're aware. Councillor McInnes.
Yeah, kia ora. Thank you very much for this. I have two questions. Hopefully they're quick. One of them, in the organisational scope, it says it applies to employees, contractors, temporary staff, or third parties, blah, blah, blah. Does that include elected members? Do we need to be in there as well?
I think that was assumed, but we could put that in.
And the second question was, I think it's covered within here, but I just wanted to ask the question because there's been a fear that I've seen expressed elsewhere that potentially councils and government might start using AI to speed up the analysis of submissions during consultation periods when, you get thousands. Let's just shove it all into an AI and tell it to give us a report sort of thing. I would like to just ask the question. That's something that would probably, in the various assessment, the we question trees there, I'm pretty sure that would fall out as a no, do not use AI in these circumstances.
Yes, and because this policy is, I call a baseline policy, when we move to the next iteration, and what you're talking about is using what I call safe or ring-fenced artificial intelligence. So that means it doesn't go out and share it with the rest of the world. It keeps it within a consciousness within an organisation. Then yes, that will be the only way we would ever put that type of AI against that type of service.
Right, thank you for that. There being no further questions, I will put the resolution. All those in favour say aye. Against? Carried. Thank you.
Thank you.
Thank you. We'll get artificially and more intelligent by the minute. Policy manual updates. We have 13(1) through to 4. I'd like to move them all together.
Query? Yeah, I've got some questions.
Questions? Okay, we're going by them one by one. First, we'll go to 13.1, restricted connections to council drinking water supplies policy. Questions?
I have one. I would like a list of those communities that are actually on those restricted supplies. I've actually asked staff, could that actually happen? So people reading the policy are made aware if they are or are not on a restricted supply. We do have a list.
I would have thought they would have known.
Yes, we do. In the current engineering code of practice, there's a list that exists around restricted and on-demand supplies. But there is a move to make that more freely available on the website with water quality monitoring data as well.
So that will be done.
Yep.
Thank you. Councillor Miller.
I just want to make sure I understand this correctly. So if on a new over 2,500 square metre section in an on-demand supply, I will be required to put in a restricted supply in my on my property and install pumps and infrastructure to re-pump pressurised water from my holding tank. Is that what this is saying?
That is exactly what
Because
it's.
the concern I raise is, how does that apply in I-zone? When you've got a whole lot of commercial properties over 2,500, does that mean you've got a whole swag of sections over there? You're going to have to install tanks and repump it?
That relates to a residential property.
Where does it say
rather
that?
than a commercial. And the commercial applications are subject to council approval and the building consent process.
Where does it say that though? Then
it can be updated to reflect that.
Because it doesn't. And it's the same thing as if you transition to this model, what will be the charging methodology? So if you're in an on-demand area, will you be charged at a restricted supply base rate plus the per cube restricted supply rate? Will be?
Yes.
It feels like we're going backwards as a district.
May I?
Yeah, sure.
Provide a
That's what I'm
little
asking.
commentary to that. Water is a precious resource, and we have some quite strict consent conditions and limits around its use, and that's an awesome thing, where our risk around large sections is predominantly irrigation. And our consents are all quite clear about what water can be used for. There's a line item in the consent that says water shall be used only for drinking water supply purposes. And a lot of those consents include an RMA reference, which says reasonable domestic needs and the needs of persons, animals. So we have to be quite careful about irrigation. And that's basically what we're trying to manage by going to a restricted supply for large sections.
Because I thought we were managing that through the water use charge, whereas if you were using a lot of water, you could charge for it, and that is self-managing. Yeah.
Sorry.
Yeah, that's right, mate. Carry on.
But the problem is that we don't have the ability to extract every ounce of water, and it's not ethically correct. Doesn't apply with Te Manawa 2Y principles or engineering best practice to pull lots of water out of the ground and just sell it. We have to be. It's a finite resource, and we have to really manage it and look after it. Otherwise, we'll be in trouble.
Thank you for that answer. Councillor Mugford.
Yeah, just a query on, you were saying you would have a list of which areas were restricted and which were not. How do you get on when there's two sections exactly the same size, side by side, and one is restricted and one's not?
It's a great question. So the water quality data that's currently being digitised so that it's visible on the website, we're proposing to use valuation number to differentiate on scheme type. So it's easy enough to overlay the connection type onto that, so people will know not only the scheme type, but also whether or not they're restricted or not.
And secondly, is the reason for those two sections being the lack of water or lack of supply? Because it's a question I get asked quite often in the rural areas. So I just find it hard to believe that if I was on one, I could swim in a swimming pool, and if I was on another, I couldn't, which doesn't seem fair to me when they pay the same rates, basically.
It is a challenge, yes. And I guess you could fill a swimming pool. You just have to do it slowly. So it's sort of, it's about people managing their available resources. And then you get what you pay for. So, you know, an on-demand connection, you pay for it.
Councillor
Two things. First is I feel that this is such an in-depth topic that I would love if this was brought back to us as a workshop, because there's just such a lot in here that I think we need to get our understanding around. It could change a lot of things for a lot of people, particularly if they can't fill up their swimming pools. Right. So we've also you've got here on page 112, policy prohibits industrial irrigation, which includes sports facilities, sports fields and schools and community drinking water supplies. But that's potentially a fair few, I imagine, a fair few parks and things. And I mean, it would be good to have that workshop to have that understanding who it's affecting.
Councillor Monk, we're just dealing with 13.1 at the moment. Yeah. So any more comments on 13.1? Well, now move for 13.1. All those in favour say aye. Against? Carried. Now we'll move on to 13.2, firefighting connections to District Council water supplies policy.
Okay. So this policy is primarily around formalising existing operational agreements, and effectively it identifies what requirements around storage on site for sprinkler systems, so that ratepayers aren't subsidising private infrastructure, basically, and also it limits. We have some capacity constraints servicing large fire demands in our district. So that's basically all this is doing, formalising that, which is a standard approach we've already adopted in terms of that.
Thank you for that explanation. Councillor Mugford.
Yeah, just on the maintenance, is council responsible for maintenance, and do you working with FENS as far as them? We've had discussion over some of them not knowing where these things are, so.
Yes,
all
so
those things.
it's usually triggered through the firefighting requirements are usually triggered through the building consent process. So this policy is creating transparency in advance of that process, and it's a good thing. It'll provide certainty for people building things. There's no maintenance associated with that for council because it's all private infrastructure.
Thank you. That's all we have on, Councillor Miller.
Just do a quick one. It's on page 119. You've got all physical water connections are required to be completed by an approved contractor with a standover from STC. Is that an engineering term? It sounds a bit sort of, I think maybe authorisation required from it. Is that a technical term, standover? It just sounds a bit sort of gangish.
Yes, so on our website, that's how it's referred to.
There's a technical term. Okay, yes. Thank you.
Okay, so that was, we're working on firefighting connections. 13.2, all in favour, say aye. Against, carried. Okay, now irrigation from council drinking water supplies, 13.3.
Yeah, I had a question on this.
Yeah, I'll go for it. So this is about our going back to the previous comments around consenting, about what our consents actually permit us to do. And that isn't large scale irrigation. So this is really the intent of the policy, is basically to ensure we comply with our consents and provide transparency around that. We have been going through the building consent process, which is usually where this gets triggered, where people think that they can have an irrigation connection, but we're unable to service it because of the infrastructure demands that will be necessary.
Thank you. Councillor Hassan?
Just one clarification with regards to this particular policy. And I'll use Raven Drive as an example because I know that it is a rural residential with 5-acre blocks or up to 2 hectares. They were on a well water, but now the council put it on the Rolleston supply. With regards to them being able to use that for irrigation, now they're on the Rolleston supply as opposed to them being on an individual supply. Are you saying to those people now that, sorry, you won't be able to irrigate under your original conditions?
It's a good question. So the policy isn't intended to be applied retrospectively to connections. So in terms of irrigation, that supply is an on-demand tank supply, which means that the tanks fill just like you turn on a tap. So they would need to manage their water use, whatever they do, within the limits of their tank. So if their tank runs dry, they can't irrigate. That's how on-demand tank supplies would operate. There's no limit to the flow into the tank. I can probably, just one more step is that they've actually got a better level of service now than they did before, because the way the scheme had to operate was it would pump for a certain amount of time and then stop. But now it's actually fed all the time off Rolleston under constant pressure. So it's actually a positive thing.
Okay.
Councillor Miller.
Will we see this policy applied to our reserves, or is this just for private commercial communication? Because the secondary issue probably is sports fields, is that if we're in the red zone here, are we going to support these people when they go to ECAN and saying we want to apply for a water consent in a red zoned area to irrigate sports fields for a health and safety reason? Have we got a policy around this?
It's a good question. So we had exactly this scenario nearly this scenario occur. There was an applicant for a school or college, and under the building consent, they applied for an irrigation connection, and we said, no, unfortunately, we can't. And they actually took the opportunity to think about whether or not they actually needed the irrigation water, and made some really interesting decisions and said, actually, we don't need to. The risk assessment and the alternate surfaces that are available mean that we don't need to irrigate. So it's actually driving some really water sensitive design, which is really a great thing. And in terms of the question for our reserves, yes, there are some challenges, and we will, going forward. So all of the previous reserves, it wouldn't apply to because they're an established connection, but anything going forward would be held to that same level.
Councillor McInnes.
Yeah, I just want to say thank you for your team's answering some of my questions around schools this morning, because I was a wee bit concerned this was going to be retrospectively applied to schools, and got some really good information back. And yeah, totally appreciate actually having it out there that water is a finite resource, especially when it comes from aquifers, and we don't know how much is down there, so we can't just extract it willy-nilly. So yeah, thank you.
Right, there being no further comment on irrigation from council drinking water supplies, I'd like to move the resolution. All those in favour say aye. Aye. Against? Carried. The next one is under pressure, falling down on me.
Go on, Mark.
Yeah, thanks. So this is another operational policy which is formalising when and where a low pressure sewer system would be acceptable to council, be considered. It's another tool in our toolbox when we have some challenges around capacity, groundwater levels, not physically being able to gravity. So the preference would always go to a gravity sewer, and the policy is quite clear around that. But this is another tool in the toolbox that developers could use to undertake discharging sewer to our network, waste to our network.
Hang on. Just
Councillor Hassan.
just briefly, where we've got now, because of increased density of subdivision, and we might have 3 or 4 lots on one section, each one would have a different sewer capacity. Is that where you envisage actually using these pressure systems?
Yeah, we gave that some really careful thought, because the policy identifies that in an area like an increased density, but where there wasn't subdivision, then effectively there would be a permission to use 1 unit. But if any further subdivision occurred, then it would be 1 unit per valuation number. So that gives some real strength to the policy around ownership and accountability, because that would all be in private land and private.
All questions have been answered on that. I'll move the resolution, pressure wastewater systems policies. All in favour, aye. Against? Carried. Thank you very much. We've been under pressure. Right, councillors, we now move on to the fantastic part of the LGNZ remits for the AGM. And I think the Chief Executive has a suggestion here for me.
Well, a suggestion to councillors that don't have to accept if there's a slight step change this year in terms of obviously we're bringing through the 8 papers to seek either council's endorsement or non-endorsement. There's an extra step in terms of then prioritising which are the priorities from the papers that have been presented. I was going to say, in terms of timeliness of councillors, considerate. Your delegates this year as Councillor Reid, Deputy Mayor Lyle, and I think Shane.
Yes.
Yes.
Councillor Epiar.
And if councillors are comfortable enough, once you've decided whether you're endorsed or not, you could leave to your delegates on your behalf to decide the priority if you didn't want to discuss that here this evening, was my suggestion.
Very good. Well, we'll go through them one by one. Representation reviews. The remit is that local government NZ advocate for changes that support the provision of timely and accurate regional and sub-regional population data to councils for use in council representation reviews. I think this is talking about the data from Stats NZ, because there's always, we're working on old data. I don't know how they would do that, but is everybody in favour of this? Anybody against it?
It fits with our submission on the changes to the census process, so yeah.
Cool. Okay, so number one's a yes. Number two, the community services card. The LGNZ advocate to central government to amend the health entitlement cards regulations so that the cardholder can use the community services card as evidence for the purposes of assessing council services, which would otherwise rely on a form of means testing. Seems pretty reasonable. Yep. Anybody directly opposed to that? We're all happy? Perfect. So next one up we have is local government constituencies and wards should not be subject to referendum. That LGNZ lobbies central government to ensure that Māori wards and constituencies are treated the same as all other wards and that they should not be subject to a referendum. We oppose the idea that Māori wards should be singled out and forced to suffer a public referendum.
And this is very much in keeping with the feedback that we gave to the submission.
Yeah. So this is reinforcing what we've done already. Everybody's happy? Number 4. Oh, that's it, is it?
No, you're not. That must be graduated driver's license.
Oh, the graduate of somehow my minutes are. Yeah, 4 and Trent. I've got that. Sorry, my order paper is graduated driver licensing system. Oh, entrenchment. Yes, sorry. Entrenchment of Māori ward seats for local government. Proactively promote the lobby to entrench the Māori wards and constituencies for the 60-ville council, which currently have these, to require the support of a supermajority of Parliament should either parliamentary council seek their removal. I support it. I have no problem. Oh, Grant.
I oppose. The last government got into real trouble with entrenchment. I don't think we should be getting into worrying about that. The one above that sorts it out. I think it's a step too far.
So any other views? Councillor McInnes.
I'm pretty much with Grant, actually.
Okay.
Entrenchment is pretty severe, but I definitely would support, all wards being treated the same. I'm just not sure that entrenchment is the right way to go about it.
Cool.
Isn't the main thing it's trying to say there is that it has to be a supermajority to change it over? Isn't that the main gist of it, as opposed to being just a new government comes in, therefore it can change?
So, yeah. They haven't got a supermajority yet.
75%.
So how are we sitting here, councillors? In or out? Out. Okay, it's out. We're not supporting that one. Number 5 is a live graduated driver licensing system. Advocate the changes to the fee structure for driver licensing, better preparing young people for driver license testing and greater testing capacity at key locations throughout New Zealand in order to relieve the pressure on driver licensing system. Well, this is basically what we've been advocating for, because we really want one out here. So, yeah. Yep. Yeah, well, I have words with you later. So is that the 5 of them? No. 6, proactive lever to mitigate the deterioration of unoccupied buildings. Okay, councillors, comments? Are we backing this or not backing this? We have a grant, Councillor Miller.
It's quite subjective when you look at the photographs from Gisborne. Some of those places they are tired, but they're not, really health issues. So how you're going to manage that would be difficult. thing to manage. So it worries me about the level of subjectivity to it.
I agree, Grant. I think it's, you look at Queen Street at the moment, there's a lot of empty buildings. What's the overall view of the council? We don't support this one? Yeah. No support for that. It's out. And number 7, appropriate funding models for central government initiatives. You proactively promote and lobby for development of more equitable and appropriate funding model for central government initiative. Yes, please. Okay, we're all on for that. That chance. Goods and services tax sharing with local government. Yes. Thank you, councillors. That's given us a clear sweep on those. All those decisions made. Everybody's. I'm just wondering that. I think we probably do a resolution that to do keep a record of.
So requests the AGM delegates to the local government to vote. So you need to.
No, we need to put what we're voting for, I think. The ones we support and ones we don't.
Yes.
So have we got, did our scribes manage to keep that?
Yes.
There it is. Excellent. So all those in favour of that, please say aye. Carried. Thank you very much.
What was that?
Sorry, Deputy Mayor, just to clarify, and is council happy for the delegates to do the prioritisation on council's behalf?
Oh, sorry, is that, are you saying that to move all of that?
Yes.
Well, I actually support entrenchment of Māori ward seats, so I want that reported.
Yeah.
But I'll support the direction of the council.
Okay.
So resolutions explored project. Are we up to that?
Are we up to that yet? So that's dealt with that. Okay, we have a resolution to exclude the public. Moved by Councillor Reid, seconded by Councillor Munt. All those in favour will say aye. Aye. Thank you.
Just wait a second. So